1, 2, 8, 9, 10. One, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Good morning. I'm Ward 1 Councilmember Nadeau, the Chair of the Committee on Public Works and Operations. Today is February 21st, 2024, and I'm calling to order this meeting of the committee to conduct a performance oversight hearing for the Office of Clean City, the Office of Human Rights, and the Commission on Human Rights. The time is 9:41 a.m. Today's performance oversight hearing will begin with the Mayor's Office of the Clean City. The office brings the work of agencies and community partners to achieve a clean, safe, and healthy District of Columbia. The office serves as a central point of contact within the mayor's administration for preventing and reducing litter and trash pollution in the District of Columbia, including pet waste and rodent prevention. I look forward to hearing from Director Phil Thomas about the office's accomplishments over the last year and learning more about the programs under the office's purview. Today's performance oversight hearing also focuses on the Office of Human Rights and the Commission on Human Rights, both integral entities in upholding civil liberties in the district. The Office of Human Rights is an important agency, and its primary function is to enforce the DC Human Rights Act and other local and federal civil rights laws. This act serves as a cornerstone of our legal framework, rendering discrimination unlawful across 23 protected traits for residents, visitors, and workers in the District of Columbia, encompassing employment, housing, public accommodations, and educational settings. However, acknowledging the imperfections in its implementation, we anticipate valuable insights from public witnesses today on refining both its protective measures and the agency's complaint resolution procedures. The Office of Human Rights is charged with providing a legal process to those who believe they have been discriminated against. It offers a right to sue in DC Superior Court and/or an opportunity to seek administrative remedies before the Commission. Upon filing a complaint, the agency conducts an intake interview, endeavors mediation, and proceeds with an investigative phase to ascertain facts. Subsequently, the agency's attorneys present their findings to the director, who determines whether probable cause exists for a Human Rights Act violation, potentially leading to formal charges. Following this initial phase, the Commission on Human Rights assumes jurisdiction. An administrative law judge presides over evidentiary hearings, formulating recommended rulings and associated penalties. Ultimately, a panel of commissioners provides an impartial perspective, culminating in a final decision. Despite this seemingly linear process, the complexities inherent in discrimination complaints often prolong litigation, particularly for self-represented litigants. Today's hearing aims to delve into these intricacies and other pertinent challenges. I'd like to thank OHR and the Commission for their prompt response to the committee's inquiries. I look forward to hearing more about their work over the last year, as well as any challenges the agency faces, so we can help them fulfill its mission to eradicate discrimination in DC. We will be hearing from the Director of the Office of Human Rights, Nin Kane, and the Chair of the Human Rights Commission, Matoko Aizawa. We value your input, and we are grateful for all you do for district residents. We value your, all right, so we are not joined by any other council members right now. So what we will do is turn to some logistics. In addition to being both in person and in the Zoom, this hearing is being live broadcast at briannenadeau.com/live. Witnesses testifying on behalf of an organization will have 5 minutes to provide oral testimony, and all other witnesses will have 3 minutes. In order to ensure we hear from all members of the public, I ask that all witnesses stick to their allotted time. All witnesses participating in this hearing via Zoom are currently in the webinar mode, which means your microphones are muted and your video cameras are turned off. But when it is your turn to join a panel for testimony, I will call your name. Someone on my team will give you an invitation to join the panel, which you must accept in order to join, at which point you can activate your camera. Please remain muted until it is your turn to testify. If you are here in person, when I call your name, please come forward to the witness table. There is a clock keeping time. When your time is up, I kindly ask you conclude your remarks so we can ensure that everyone has a chance to be heard. All right. For any technical difficulties, send a message in the Zoom to our host labeled as DC Council Committee on Public Works and Operations, or any panelist labeled as PWO committee staff, and they will follow up with you. If you're having trouble gaining access to the Zoom and you've pre-registered, you can reach us at publicworks@dccouncil.gov and we will help troubleshoot your issue. All right. Our first panel of witnesses includes Susie McClanahan, Equal Rights Center, Senior Fair Housing Rights Program Manager. Allison Tallering, First Shift Justice Project staff attorney. Rosalind Herendine, first shift. Mariato Okonofua, DC's Children's Law Center Public Service Legal Policy Fellow. Nancy Leon, Many Languages, One Voice. William Jordan, Michael Syndrome, Farrah Fossey, National Domestic Workers Alliance. So if I've called your name and you're here in person, please come forward to sit at the table. And if you're in the Zoom, please accept the invitation to be promoted to the panel. We will go in the order that I called the names, so we will begin with Susie McClanahan when you are ready. Thank you.
Great. Hello, I'm Susie McClanahan, the Senior Fair Housing Rights Program Manager at the Equal Rights Center. The ERC appreciates the opportunity to testify at OHR's Performance Oversight hearing. The ERC is a civil rights organization that identifies and seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in its home community of Greater Washington, D.C. and nationwide. The ERC, as a complainant or non-attorney representative for complainants, has filed more than 50 fair housing complaints with OHR in the last 3 years. The ERC commends OHR on the increase in fair housing complaints docketed in the last 2 years. As the number of complaints grow, we do have significant concerns about OHR's ability to keep pace. 10 ERC clients have open complaints that are more than a year old, with the oldest ones dating back to 2021. Delays in the administrative complaint process appear to have worsened, especially at the intake stage. 5 ERC clients waited about 6 months from the initial filing of their complaints last year to the docketing of the charge. Many complainants have shared that the complaint process is time-consuming, resource-intensive, and confusing, to the extent that it deters them from filing or following through on complaints. OHR has stated its plan to use fact-finding conferences during investigations in order to decrease the growing backlog. While the ERC appreciates OHR's intent to address the complaint backlog, we are gravely concerned that fact-finding conferences can make the complaint process more emotionally draining and difficult to navigate for complainants. The ERC files for housing complaints at 5 government agencies in its service area. Of those, only 2 have used fact-finding conferences. In a fact-finding conference, the investigator holds a meeting between both the complainant and the respondent and takes statements from both parties while they are together. Our experience has been that victims of discrimination generally find it difficult to clearly articulate their experiences in such a high-stress environment, especially when there can be such a significant power imbalance between them and the housing provider. One ERC client that participated in a fact-finding conference called the experience more traumatic than her experience of discrimination. We appreciate that OHR has stated that fact-finding conferences would be voluntary and would further encourage OHR to maintain its current investigation process for all fair housing complaints. The challenges with the complaint process highlight the heavy enforcement burden put onto victims of discrimination. With fair housing complaints frequently taking 1 to 3 years to reach a resolution, complainants are required to relive the discrimination they experienced over and over again as their complaints slowly progress through each stage. As such, it is critical that the district's civil rights enforcement agencies, including OHR, do everything in their power to fight discrimination at a systemic level. The Fair Housing Act and DC Human Rights Act allow for claims based on a disparate impact theory. Policies and practices by housing providers that appear neutral could be considered discriminatory under a disparate impact analysis if they have a disproportionate impact on a group of people protected by fair housing laws. Disparate impact provides a powerful tool to address systemic forms of discrimination because it makes it possible to identify and challenge more pernicious, difficult to see cases. For example, because over 90% of the city's voucher holders are Black, discrimination towards voucher holders in DC is also race discrimination. Additionally, overly broad criminal record screenings may be discriminatory on the basis of race or national origin, as the screenings are disproportionately likely to serve as a barrier to renters of color. Given historic and ongoing discrimination that has yielded stark residential segregation, the district should use all the tools at its disposal to promote integration and equity in housing. Yet the director has stated during OHR's most recent performance oversight hearings that the agency does not accept disparate impact claims because they are resource intensive and the agency lacks the staff capacity necessary to investigate them. To effectively address the systemic discrimination that plagues the district, OHR must take the necessary steps to accept disparate impact base for housing complaints. Should OHR need additional resources or staff to investigate disparate impact claims, the ERC urges DC Council to address this budgetary gap. Relatedly, OHR can more proactively address housing discrimination and reduce the burden on victims by conducting director inquiries. OHR did not open any fair housing director inquiries in fiscal year 2023. Yet blatant housing discrimination occurs with frequency, especially based on source of income. Discrimination against voucher holders is serving as a mechanism of racial segregation and must be stamped out. OHR should fully use its authority to launch director inquiries in order to respond to rampant source of income discrimination. Lastly, while we have raised several concerns about OHR's performance in today's testimony, we also want to stress the critical role OHR plays in enforcing the district's progressive civil rights laws. We understand that this is a tough budget year, but any budget cuts to OHR would be devastating. The agency has only been fully funded in the last few years, meaning that any budget cuts would significantly hinder the agency's mission and make it more difficult for residents to meaningfully report housing discrimination. Thank you for this opportunity to testify.
Thank you so much. We'll now hear from Allison Tallering, First Shift Justice Project.
Good morning, Councilmember Nadeau, members and staff of the Committee of Public Works and Operations. My name is Allison Tallering, and I'm a staff attorney speaking on behalf of First Shift Justice Project, a nonprofit providing legal services to low-income parents and caregivers at work to help them prevent job loss. First Shift Justice Project has represented clients at the Office of Human Rights for many years. We welcome the opportunity to share our feedback with the committee regarding 3 issues: our support for the Fairness and Human Rights Administration Amendment Act of 2023, Bill number B250319, with a focus on the election of remedies provisions, the need for OHR to accept attorney-drafted charges without revision, and the need to incorporate the Protecting Pregnant Workers Fairness Act into the DC Human Rights Act. Currently, working parents and caregivers who file at OHR after experiencing discrimination or mistreatment do not have the ability to file a civil suit in court after OHR makes a determination as to the disposition of their claims. First Shift Justice Project has been testifying about this issue for 5 years, most recently in the Bill number B250319 hearing on December 6th. We come again to the Committee on Public Works and Operations to call on the Council to pass Bill number B250319 for the following reasons. The election of remedies provisions disadvantage pro se complainants, people moving through the OHR process without an attorney, who are more likely to work in low-wage jobs. These complainants are unwittingly waiving their right to sue in court when they file at OHR and see the process through to completion. OHR is not required to give notice of this waiver at any point in their process. Pro se complainants may also be more likely to receive a no probable cause determination because of the lack of guidance from an attorney, after which they are precluded from any other remedies, even if their underlying cases have merit. Precluding the ability to go to court after a determination is also inconsistent with administrative practices under federal law. Additionally, First Shift Justice Project recommends that the committee maintain Bill number B250319's current language regarding the timeline for withdrawing claims and issuance of a notice of right to sue letter. We would also like to recommend that the committee add language that expands the statute of limitations for discrimination claims from 1 year to 3 years to allow more workers who are often separated from their employment in times of personal crisis access to justice for their illegal mistreatment and allow them to take part in filing claims at OHR. Next, First Shift Justice Project wishes to highlight the need for intake officers at OHR to accept attorney-drafted charges without revision. This has been a long-time issue on our radar, and we appreciate that OHR took the positive step towards accepting them when they implemented a pilot program in 2019. The reasons we recommend this policy change on behalf of OHR are as follows. OHR intake staff are generally not trained lawyers and therefore inappropriate parties to judge the legal sufficiency of narratives submitted by complainants' attorneys. If intake staff members eliminate facts, reword or reorder events, or otherwise edit what attorneys have provided in the intake narratives, it can deprive claimants of the ability to have their claim judged properly, either at OHR or when complainants withdraw their claims and file in court. Using the OHR intake interviews as a way to test a complainant's credibility or the sufficiency of their claim is contrary to controlling regulations. Eliminating facts from charges because the complainant, who may already be under significant emotional strain after having to relive their experience of discrimination for the intake officer, can't recite with precision what they've already provided to the agency in their written questionnaire is unnecessary. These changes can add to the delay complainants face when interacting with OHR, both in the time it takes for the intake officer to revise what the attorney has submitted, and in the extended correspondence with the complainant and their attorney over the revised content. Accepting attorney-drafted charges is one step that the agency can take to help clear their already significant backlog. Finally, First Shift Justice Project would like to recommend that the committee incorporate the Protecting Pregnant Workers Fairness Act into the DC Human Rights Act. Currently, the Protecting Pregnant Workers Fairness Act protects pregnant workers who request reasonable accommodations and allows them access to job-protected leave to recover from childbirth. Important protections that are not accompanied by a strong enforcement framework. People who are denied pregnancy accommodations can receive back pay for lost wages as a result of the discrimination, reinstatement, and reasonable attorney's fees under the PPWFA, but the statute does not provide for additional compensatory or punitive damages where the DC Human Rights Act does. The Federal Pregnant Workers Fairness Act has also provided for additional damages since June 2023. Increasing potential damage awards will also help OHR shepherd more cases into settling during mandatory mediation and decrease the investigative backlog, given that the employers will have more on the line if complainants choose to proceed to court. We believe pregnant workers would be better served and employers would be more likely to comply with the law if the more expansive remedies provided for under the DC Human Rights Act were available to pregnant workers denied reasonable accommodations or retaliated against for requesting them. Thank you.
Thank you very much for your testimony. Next, we'll hear from Rosalind Herendeen.
Good morning, and thank you for the opportunity to testify today. My name is Rosalind Herendeen, and I'm also an attorney at First Shift Justice Project, a nonprofit legal organization whose mission is to help low-income parents and caregivers assert their workplace rights to prevent job loss. First Shift routinely represents individuals at OHR at all stages of case processing. In practice, we've seen that the ongoing and severe delays in case processing at OHR compromise and in some cases prevent our clients from pursuing their cases and getting a remedy for the discrimination they've experienced at work. We currently represent an individual who filed a complaint of discrimination with OHR in October 2017 after her employer, days before she was scheduled to return to work from her parental leave, told her that there was allegedly no funding for her position and no job for her to return to. My client, who had a newborn at home, had no income and no assurance of future and steady employment. My client's complaint has been pending at OHR for years. Finally, in September 2023, nearly 6 years after the complaint was filed, my client received 2 probable cause findings. This should have marked a cause of celebration for my client. It was not the final outcome of her case, but it represented a moment where there was finally a degree of recognition for what she had been through at work, and I hope that she might obtain relief for the discriminatory treatment she experienced. However, after initial efforts to conciliate the case, my client was confronted with a situation that I have seen develop with increased frequency as the delays with case processing at OHR continue. Her former employer was no longer active. They had gone out of business. Despite the merits of her case, my client, after nearly 6 years of fighting her case, has potentially lost access to a meaningful remedy. There is no active business entity for her to conciliate with or to oppose at a hearing. Businesses change ownership and they stop operating. Neither an individual complainant nor the DC Office of Human Rights can do anything to change that. But the longer a case remains pending at OHR, the more likely it is that a complainant's former employer is going to experience some kind of change to its business. And those changes to the respondent have significant implications for complainants' ability to pursue their cases and obtain relief. Taking steps to process cases faster and more effectively would be particularly valuable to complainants who, like many of our clients at First Shift, were in low-wage jobs and have limited damages. These complainants are particularly reliant on the OHR process to seek relief because it often does not make sense for them to file in court. Many cannot reasonably represent themselves pro se, and many attorneys are reluctant to take on these cases from a financial perspective because of the limited damages. In these situations, OHR is a very important forum for our clients because it provides them with a mechanism to obtain a remedy. Thank you again for the opportunity to testify today.
Thank you very much for your testimony. Next, we'll turn to Mariatu Okonofua.
Good morning, Councilmember Nadeau and members of the committee. My name is Mariatu Okonofua, and I'm a Public Service Policy Fellow at Children's Law Center. Thank you for the opportunity to testify regarding the Office of Human Rights. Through our medical legal partnership, CLC represents families seeking special education services for their children, many of whom have limited English proficiency. These families often struggle to receive communications about their children's educational services in their preferred language. As a result, these families are denied access to federally mandated services and experience isolation and exclusion during key educational meetings. The Language Access Act requires OHR to monitor the accessibility of programs and services offered by covered entities, including DCPS and OSSI, to ensure that they meet acceptable standards of translation or interpretation. As a note, charter schools are not considered covered entities under this law. Through its Language Access Program, OHR oversees enforcement, compliance monitoring, and technical assistance to covered entities. Though the LAP has improved accountability for violations of the Act, we continue to see gaps in language accessibility, especially for students with disabilities and their families. My testimony today will focus on key improvements needed to address noncompliance in the district. For years, limited or non-English proficient students and their families have experienced denials of their language access rights in the education sector. For example, schools often do not provide translation of vital documents or are extremely delayed in doing so. Moreover, in IEP meetings, school staff sometimes interfere with oral interpretation and thus exclude families from decision-making. OSSI has also neglected families' language access needs by only sending text message updates in English. In late 2023, CLC brought this issue to OHR's Language Access Program Director. The director promptly met with OSSI and worked with them to develop short and long-term plans to address these failures. We appreciate the LAP for their quick response to address this issue, and we hope to see improvements from OSSI DOT soon. However, to better meet the language access needs of DC students and families, more is needed. For example, the LAP should provide technical assistance to DCPS regarding school-level implementation of their language access policy. Further, the LAP should work with DCPS to reduce wait times for the translation of IEPs and related documents. Additionally, OHR and the LAP should partner with the Office of the Chief Technology Officer to identify a new language interpretation servicer. Our clients frequently experience inaccurate interpretations of special education terminology in meetings where the language line is used. We know that the LAP director has been working with Octo as it prepares for the end of its current language line solutions contract in September. We urge this committee to ensure that OHR's expertise is given considerable weight in choosing the next vendor for interpretation. Finally, to ensure students and families' language access needs are met, we urge OHR to expand capacity at the LAP. Currently, the program has only 3 permanent staff members. Among the permanent staff, only 1 person oversees training and compliance for the entire district. With additional staff, the LAP could dedicate more resources to monitoring and technical assistance, conducting foreign language field testing, and analyzing trends in noncompliance. Increased capacity would also allow the LAP director to focus on broader priorities and develop systemic solutions for pervasive language access violations. Thank you for this opportunity to testify, and I welcome any questions.
Thank you very much for your testimony. Next, we'll hear from Nancy Leon.
Good morning. This is America. Remembering that still hurts because it was such an unpleasant moment. I did not want to renew my insurance, but I knew I had to. My daughter saw the way they were treating me. I asked for an interpreter, and they told me no. My name is Nancy Leon, and I'm the Director of Advocacy at Many Languages, One Voice, and a member of the DC Language Access Coalition, also known as DCLAC. These were just a few quotes from a listening session we hosted last year with Spanish-speaking members of our community. They were sharing their experiences interacting with DC agencies. We had many of these members want to join us today, but could not due to their work schedules. All of the interactions that MLove and DCLAC have had with OHR have been positive. We're so grateful for their support, providing the coalition with updates, conducting language access violation investigations, and the reports that they provide on the state of language access in DC. However, if the Language Access Act itself has gaps that are not serving all our non-English speaking community members, then there's only so much that OHR can do to uphold it. I'm here today to offer my support to the proposed amendment to the DC Language Access Act, which would establish an enforcement mechanism for agencies that violate the Act. Over the last 2 years, DCLAC has been working on a proposal for an amendment that includes an enforcement mechanism. We're so thankful to you, Councilmember Nadeau, for your leadership in agreeing to support the amendment. We believe that without it, the Act's effectiveness is limited and agencies might not be prioritizing compliance with the Act. As the Director of Advocacy at MLove, I have witnessed firsthand the barriers that limited English proficient residents face when they're trying to access government services, from healthcare to housing. And if we don't improve the law, then it can lead to continued systemic inequities and deny our diverse community from their fundamental rights. In conclusion, I urge the council to consider supporting the proposed amendment to the DC Language Access Act in the following budget season, and DCLAC has requested meetings with other council members of this committee to brief them on the amendment proposal. Together, we can build a more just and inclusive city. Thank you so much for your leadership and your time.
Thank you very much. Next, we'll hear from William Jordan.
Good morning. My name is William Jordan, a 30-plus year resident of Columbia Heights in Ward 1, a ward in which over 18,000, 50% of my Black neighbors of all incomes have been displaced since 2000. To make room for denser development, wealthier white immigrants as a matter of government policy. In the last 10 years or so, I've seen government neglect cause once thriving, high quality public spaces such as the Columbia Heights Public Land deteriorate due to neglect, fear-driven defensive urbanism. While restaurants, bars, and developers and tech giants gobble up public space to serve privileged immigrants. Further, it has been commonplace for elected and other officials and a small group of supporters to use arcane and esoteric zoning processes to limit the political voices, housing options, and political aspirations of Black families in the ward, especially those families with children headed by lower and moderate income Black women, all in the name of so-called affordable housing structured to serve high-income individuals at the expense of families. To quote the mayor's Black Homeownership Strike Force report, less Black homeowners, has also fallen dramatically, with a net loss of 5,000 Black homeowners from 2010 to 2020, exacerbating the racial homeownership gap. The current rate is 34%, is a drop from Black homeownership rate of 46% in 2005. This dynamic is especially the case in Ward 1, which has seen a displacement of half its Black residents. Systematically over the last 15 years, schools, churches, businesses who for years have served the ward's Black residents have closed under pressure for so-called reform, land speculation, regulatory harassment, and displacement of their customer base, all in the name of growth. Something is rotten in our Ward 1 Denmark for growth, development, and the inclusion of Black families in the prosperity of our ward over the last 10 years, especially viewed from a racial equity lens. Yet the Office of Human Rights is a member of task force, committees, advisory boards, membership organizations, but not one which specifically addresses the great displacement of Black families and institutions from Ward 1 and other neighborhoods in the city. I urge the Office of Human Rights to immediately design and set up a task force to get a better understanding of the great Black displacement, the policies and other biases that drive it, and look for solutions for repair. I'll end there. Thank you.
Thank you very much. We'll now hear from Farrah Fawcett.
Good morning, Councilmember Nadeau. My name is Farrah Fawcett, and I'm here on behalf of the DC chapter of the National Domestic Workers Alliance. I'm here today with a number of our members who will also testify about the Office of Human Rights implementation of the Domestic Worker Employment Rights Amendment Act of 2022. As you know, this important law was the result of years of domestic worker organizing to ensure that people who work in private homes, including nannies, house cleaners, and home healthcare workers, have the same protections afforded to other workers in the city. The law reverses the legal exclusion of domestic workers from the DC Human Rights Act. That was the result of over a century of racism and sexism dating back to enslavement. It also takes several big steps towards making the conditions of domestic work safer, more dignified, and more fair. OHR is charged with developing, maintaining, and making available written guidance documents about common forms of employment discrimination and guidance for how employers can comply with this new part of the Human Rights Act. We were pleased to see OHR's press release on this, and OHR did do a training with DOES and NDWA this fall. Workers left with the feeling that DC government supports domestic workers. However, we would like to see these trainings be more accessible and have more stronger language access, better Spanish interpretation and translation, and just generally more accessible language, even in English. It's a very common experience for non-English speaking DC residents to be unable to access important DC government resources because they're not consistently, reliably, or correctly translated. A huge percentage of domestic workers in DC are non-English speakers. Ensuring that guidance documents and outreach materials in Spanish and other common non-English languages spoken in DC is essential to ensuring that domestic workers know about their new rights under the Human Rights Act. We're also interested in learning more about how OHR will share guidance and ensure that their guidance around Domestic Worker Employment Rights Act and OHR's existing website and materials is translated and accessible. Along with other community partners, we're concerned that the OHR complaint process is slow and backlogged. We support reforms to ensure that this process can be faster and more viable for domestic workers who have been harmed, including by supporting attorney-drafted charges. Given the nature of domestic work, a slow complaint process could be especially dangerous for a domestic worker. If a worker makes a complaint against discrimination against their employment while still working for them, they may be alone with that employer in the employer's home while the complaint process plays out. In the case of a worker who's fired or is owed wages, this can create a precarious situation, given that most domestic workers earn low wages, do not receive benefits, and may lack access to safety net resources during times of financial difficulty. OHR has funding for 2 additional staff roles to implement this new law and enforce the provisions. Having these positions will be critical to ensuring that workers' rights can be enforced. We would like to find out if the hiring process is started. At OHR, we don't want these critical positions to be lost in the next budget cycle if they're not filled. We also support the inclusion of the Pregnant Workers Fairness Act in the DC Human Rights Act. Discrimination related to pregnancy is all too common for domestic workers. Now that domestic workers are included under the act, we need to make sure there's a process for enforcing their rights and making them meaningful. We look forward to continuing to partner with Office of Human Rights to ensure that domestic workers and employers are aware of their rights and obligations under the law and ensure there's an accessible, expedient enforcement process when violations do occur. Thank you.
Thank you so much. I just want to make sure Michael Syndrome has not joined us. We don't see him here. Okay. If he comes in, we'll try to accommodate him on the next panel. So thank you, everybody, for your testimony. To our colleagues at the Equal Rights Center and First Shift Justice, thank you for your testimony specifically about the people that you serve. One question I had, how long did it used to take between filing and docketing?
This is Susie at the Equal Rights Center. I would say that previously it might take about 2 to 3 months to get an intake interview from the filing of an inquiry. And then depending on the number of inquiries they were processing, it could be a matter of days to another probably month or 2 before the draft charge was provided to the client and signed. So the entire process may have previously taken 3 to 4 months, but there have been further delays this year, at least in the fair housing complaints.
So about how long is it taking?
Right now, probably like 4 to 6 months.
Okay. And where is the change? What part of that? Is it the initial interview that's taking longer?
I think part of the issue is that the intake officer for the fair housing team, at least, so OHR has several teams and they process different types of complaints. So the green team takes fair housing complaints and essentially, I believe, any sort of non-employment complaint. And the intake officer for that team, I believe, has either been on extended leave or left in April or May of last year. And to the best of my knowledge, they've been having their investigators be the ones who are now also doing intake. So there's now like a zero sum. Either they continue investigations and then no new complaints are processed, or at least they're not processed in a timely manner, or they turn their attention to processing all the new intakes that are coming in, but they're unable to move through the complaint investigations that their general job duties are that they have. So I think that there's a staffing issue currently that is worsening the situation for at least fair housing complaints.
Other folks want to chime in at all? I guess, Ms. McClanahan, this would also be, do you have a sense of how many disparate impact claims might be brought if OHR were to accept them?
So the ERC's position is that source of income discrimination is generally race discrimination, given the stark demographic divide between, in DC, while about 47%, I want to say, of DC residents identify as Black, well over 90% of folks with vouchers, households with vouchers identify as Black. So source of income discrimination is serving as a tool of race discrimination. But we can't file those complaints as race discrimination at OHR, which I think is losing part of the larger understanding of why source of income discrimination is particularly abhorrent. In addition to that, criminal record screenings in housing could be discriminatory based on race or national origin if they're disproportionately impacting people of color who are much more likely to have criminal records due to racism in our criminal legal system. But right now, generally speaking, an individual really can only file a complaint under the Fair Criminal Record Screening for Housing Act of 2016 and not a Fair Housing Act or Human Rights Act complaint based on race. And so that results in them having access to different and more limited remedies than if they could file a race claim under the Human Rights Act. And so the remedies that they're entitled to, such as monetary compensation, are much more restricted because they aren't able to file a disparate impact claim.
Thank you so much. Ms. Okunafwa, you recommended that the language access program should work with DCPS to reduce wait times for IEPs and docs. How long does that usually take?
DCPS individual schools have up to 45 days in order to translate IEPs, evaluation reports, any vital documents. That's the policy that DCPS instated in 2020, and it hasn't been updated since. So it kind of ranges. We have one case where it's been past 45 days. I can't exactly recall the amount of days, but it's well past 45. That answer your question?
Yeah, absolutely. I mean, what do you think is a reasonable amount of time?
It's also included as a note in my testimony, but I think that using a comparable timeline to what's included in the Chapter 30 regulations, which is 5 days prior to any meeting that revolves around the IEP. And if it can't be translated exactly in that number of time based off of whatever delays may happen, 15 days at most afterwards, so that parents can actually be meaningful participants, in that meeting and during the process. Otherwise, they're effectively denied from understanding what's happening.
Yeah. So if the documents haven't been translated in time for one of those meetings, which seems like could be fairly common, what happens in lieu of that? Translation services?
Usually the language line is called. If the school does have a bilingual staff member, they can be called in, but that doesn't always mean that the bilingual staff member understands the jargon within the IEP.
Right.
Same thing happens with the language line often, that they just do not understand what is actually being said in the IEP and what services are needed. So at one point, we actually had a client who almost rejected a part of their student's IEP because it was improperly translated. And thankfully we had a bilingual staff attorney, but we don't have many of those, who was able to intervene and say, hey, that's actually not what's said in the IEP. Can you translate that properly, or I'll translate it myself?
And those are highly technical documents.
Very much so.
Right. That determine the care for your child.
Exactly.
Okay.
Exactly.
All right. Thank you for that. I appreciate it. Oh, Ms. Tallering, you mentioned in your testimony that OHR did a pilot program for accepting attorney drafted charges without revision. How long did that last? And do you have any sense of why it wasn't implemented permanently?
I'm actually not sure about that. I started on as a staff attorney here in 2020, so I wasn't here during the pilot program, but we can follow up in supplemental testimony.
Okay, great. Excellent. Well, thank you everybody for your testimony. I really appreciate you coming in today and joining via Zoom. Okay, and Michael Syndrome has joined, so we'll have him join the next panel. Okay, our next panel includes Gladys Sandoval and Rosemary Toricio. We're gonna get some translation services set up, so folks just bear with us. Oh, I called, yes, I called Gladys and Rosemary. Yes, and Angelica Maria Martinez de Rivera. You may want to sit between the two of them if you're translating for both. Yeah, so I would have you switch seats. Put him in the middle. Let's see. There you go. Thanks, Farah. Momentito. Okay. And then, okay, is Angelica? Angelica's not here.
Buenos días, mi nombre es.
Momentito, por favor. Okay, and then we're also going to call up in the Zoom Tripti Patel, Commissioner from ANC 2A03, Allison Miles Lee, bred for the City Managing Attorney, Sophia Balamian Spencer, Washington Lawyers Committee for Civil Rights and Urban Affairs, Workers' Rights Attorney. You can come on up and take the last seat. Is Jairo here as well? Okay, just a minute. Once we finish with the translation, we'll have a seat for you. Okay, thank you for your patience. I appreciate it. So Jairo Nunez from IUTA, who's a Senior Language Access Coordinator, will also join us here in a moment. Angelica, if you are in the Zoom, can you raise your hand? We think we might see you under a different name.
Hola, buenos días.
Oh, okay, very good. I got you. Okay, very good. And then also Michael Syndrome. Is Michael in the Zoom? Okay, so let's promote Michael. Okay. So we'll begin with Michael Syndrome. You may begin your testimony. You have 5 minutes. Thank you.
Okay. Hola, buenos días. Mi nombre.
Ms. Fuentes, Ms. Maria, momentito.
Okay.
Okay, Michael Syndrome.
Yeah.
Can
Can you hear me, Madam Chair?
Yes.
Hello?
Go
Madam Chair,
ahead.
can you hear me?
Yes, sir. You have 5 minutes. Thank you.
Thank you, Madam Chair. Good to hear your voice. Office of Human Rights has gone from bad to worse. They've got a deceitful, disingenuous tact to squash cases for convenience sake. You can use that for any guise, any pretext, and if you'll see, no new cases are docketed for the most part. In the past, at least they would be docketed. You'd have at least one bite at the apple, and the golden gem of OHR is mandatory mediation. Now, getting squashed out the gate for convenience sake, they'll show no backlog, no required mediation, no nothing, and that ought not be. There's been a dramatic turn and change in enforcement of law and case numbers and so on, and this is not good. So for convenience sake, needs to be done away with. And also the current director, Nin Khan, previous General Khan, needs to go. And then they brought in to Ken Saunders, recycled. He went over to Fairfax, come back, and round we go. When will the spirit and intent, legislative intent, be honored? We the people to be heard, and moreover, the law to be enforced, because it's not. Again, for convenience sake, is nonsensical, and you can use that any which way to dispose of weighty meritorious cases for convenience sake. I understand the office may have a backlog, or did, may suffer from lack of adequate resource, lack of manpower, and so on, but that's on the government's end, and they need to square that away. There's more than sufficient funds in the budget, in the coffers, to take care of this. And folks know that when the cat's away, the mice will play. On the street, you ask about OHR, people laugh. What is that? But conversely, when you talk about OSHA, all right, businesses cringe, and they say, what will it take to get you, out of our face, to get moving on? And that's not the case with OHR, and that ought not be. That's not good. So again, the catch-all phrase, for convenience sake, needs to be omitted. It's not well-grounded in fact or warranted by existing law. Also, the mediation, who is heading that up? In the past, it was a 50-year experienced mediator, Georgia Stewart. Now, I have no idea who it is. And it was, I'm trying to think of who it is, but they change, and there's no continuity, which is not good. It doesn't leave credence, give rise to confidence in our government and in the office, which is supposed to be there for us all, champion of the underdog, and it's not. We need to carefully look at that and reassess where we're at. I understand, with Zoom and COVID, things have changed dramatically, but yet and still, the law is in effect, as is the Constitution. And due process, fundamental fairness is still carries a day, but it's not with the Office of Human Rights, sad but true, and the Commission also as well. The Commission just seems to be rubber stamped. I haven't heard a word about who, who's running who and who's Zooming who and whatever. But this is not good, Madam Chair. And so I can't emphasize enough, for convenience sake, that's madness, and that ought not be. So I'm teaching the angels of your better half to remedy that and modify that. In the past, when OHR was following the law, it was an effective, efficient medium to air out our concerns, human rights across the board. That's why the council put in place the strong wording of mandatory mediation, and to get one bite at the apple, have one bite at the apple. Now that's no longer the case, and that ought not be. So I'll defer to you, Madam Chair, and to get this right as the chairwoman. If there's any questions, I'd be delighted to field them at this time, and I want to ask again, who heads up the mediation? Was Santiago, who's gone, and then they brought in
We'll find out, Mr. Syndrome. Thank you so much. Appreciate your testimony.
Sanders was there. He went over to Fairfax, is back now. Just, musical chairs. That's not good.
Thank you so much,
You could,
Mr. Syndrome.
sake, not good. What are you saying, Madam Chair?
Oh, that's time. Thank you so much, Mr. Syndrome. Thank you so much for your testimony. We will now hear from Gladys. Gladys, sí.
Buenos días, Comité de Derechos Humanos.
Good morning, Committee of Human Rights.
Mi nombre es Gladys Sandoval y soy miembro de la Alianza Nacional de Trabajadoras del Hogar del capítulo de DC.
My name is Gladys Sandoval. I am a member and leader of the National Alliance of Domestic Workers, DC chapter.
Por más de 25 años me he dedicado a ser trabajadora del hogar en este país, en el área de Washington, D.C.
For more than 25 years, I have worked as a domestic worker in this country in the DC area.
Yo represento a una de las miles de compañeras que hacen el trabajo de niñeras, limpiadoras de casa y cuidadoras a personas mayores o con necesidades especiales.
I represent one of thousands of nannies, house cleaners, and home caregivers for people who are elderly or have special needs.
Un trabajo que demanda mucha responsabilidad, respeto, amor, paciencia y entrega.
It's work that demands a lot of responsibility, respect, love, patience, and determination.
También quiero decirle que trabajando en las casas privadas sí hay riesgo.
I also want to say that there is a risk with working in private homes.
Como trabajadora del hogar me arriesgo todos los días a tener algún tipo de accidente, por ejemplo, una caída, un resbalón o una quemadura.
As a domestic worker, I am at risk every day of having some type of accident, for example, a fall, a slip, or a burn.
Recientemente tuve un accidente mientras trabajaba limpiando una casa.
Recently, I had an accident while cleaning a home.
Mientras limpiaba el baño, de la puerta de la ducha de vidrio se rompió y cayó sobre mí y me rompió mi cabeza.
While I was cleaning a bathroom, the glass shower door broke and fell on top of me, breaking my head.
Tuve que seguir trabajando y terminar el trabajo.
I had to keep working and finish the job.
Mi empleadora no dijo ni hizo nada.
To make matters worse, my employer did not say anything about what happened or did not do anything.
Para el colmo, tuve que ir a urgencia por mí misma.
To make matters worse, I had to go to urgent care on my own.
Para mí, la salud y seguridad en el trabajo significa que todas las trabajadoras del hogar tengan información de cómo mantenerse segura en el trabajo.
For me, health and security at work means that all domestic workers have the information they need to keep themselves safe at work.
Y también podrían preguntar a sus empleadores sobre condiciones de trabajo seguro
And can also ask their employers for safe working conditions
y recibir asistencias si tienen algún accidente en el trabajo.
and get some help if there is some accident at work.
Desde que el Consejo de DC aprobó la Carta de Derechos de las Trabajadoras del Hogar,
Since the DC Council approved the Domestic Worker Employment Rights Amendment Act of 2022,
siento que se está creando conciencia de lo importante de la seguridad en el trabajo.
I have felt that consciousness about the importance of workplace safety is being built.
Me siento orgullosa de ser una de las trabajadoras del hogar que luchó para ser incluidos en los derechos humanos.
I am proud of being one of the domestic workers who fought to be included in the DC Human Rights Act
Y tener un contrato escrito y ser incluidos en la salud y seguridad.
have a written employment contract, and be included under health and safety laws.
Algo que nos merecemos todas las trabajadoras del hogar de la ciudad de Washington, D.C.
Something that all domestic workers in DC deserve.
Yo soy una de las personas que estoy haciendo alcance en D.C.
I am one of the people doing outreach in DC,
gracias a la subvención de fiscal general.
thanks to the Office of the Attorney General's grant program.
Una de las cosas que más escucho mientras hago alcance
One of the things that I hear the most while I do outreach
es cómo decirles a los empleadores los derechos que tenemos sin miedo a perder el trabajo.
is how to ask employers for a written contract without the fear of losing your job.
En nombre de todas las trabajadoras del hogar, pido a la Oficina de Derechos Humanos
On behalf of domestic workers, I would like to ask the Office of Human Rights, OHR,
que hagan que esta ley que ganamos el año pasado funcione.
to ensure that the law that we won last year works.
Necesitamos más divulgación de la responsabilidad de los empleadores
We need more outreach to employers regarding their responsibility
que deben tener sobre nuestros derechos
that they need to have regarding our rights.
Y pedimos crear un proceso de queja más accesible y más rápido.
And we ask you to create a complaint process that is faster and more accessible.
Muchas gracias.
Thank you very much.
Gracias. Now we will hear from Rosemary Soricio.
Buenos días a la Oficina de Derechos Humanos. Mi nombre es Rosemary Torrico y soy miembro de la Alianza Nacional de Trabajadoras del Hogar del capítulo de DC.
Good morning to the Office of Human Rights. My name is Rosemary Torrico. I'm a member of the National Alliance of Domestic Workers, DC chapter.
Después de 4 años de una continua lucha, en diciembre del 2022, la Alianza Nacional de Derechos de Trabajadoras del Hogar del capítulo de DC ganamos la carta en el Consejo.
After 4 years of continuous work, we succeeded in December 2022, us from the Alliance of Domestic Workers, to get the bill passed in the council.
Esta ley favorecerá a más de 9,000 trabajadoras del Distrito de Columbia, como ser niñeras, limpiadoras de casas y cuidadora de adultos mayores.
This law helps 9,000 workers in the District of Columbia, including nannies, house cleaners, and home health care workers.
Con un contrato de trabajo, seguridad laboral y de salud, y también estar incluidas en la Carta de los Derechos Humanos.
With a contract including health, safety at work, and also inclusion in the DC Human Rights Act.
Esta carta realmente fue un gran logro y gran alegría para esta área de trabajo, porque sabemos que siempre ha habido discriminación.
This bill was really a huge win and a source of happiness in our area of work because we know there's always been discrimination.
Las trabajadoras han sufrido en sus diferentes trabajos acoso sexual, discriminación verbal, acoso por su estatus migratorio, por la raza, la religión y por muchos otros factores.
And this is really a source of great distress because workers have suffered many times of harassment, including sexual, verbal, migratory status, because of race, because of religion, and many other factors.
Y estamos en el siglo XXI y esto ya no debería existir. Todos deberíamos ser respetados en todo sentido.
We're already in the 21st century. This should not exist anymore. We should all be respected.
Personalmente participé en las diferentes acciones para obtener esta Carta de Derechos de Trabajadoras del Hogar.
Personally, I actively participated along with many of my fellow workers to ensure that this law was approved.
Junto a miles de compañeras.
Next to thousands of colleagues.
Y actualmente soy parte del equipo de liderazgo que con fondos de la Oficina del Fiscal estamos haciendo alcance.
And currently, I am part of the leadership team that with funds from the Office of the Attorney General, we are working on the implementation of this law and the follow-up.
¿Y cuál es nuestro objetivo? El hacer conocer esta ley al mayor número de trabajadoras posibles aquí en DC.
And what's our goal? That as many domestic workers as possible know about the law here in DC.
Y para eso hacemos alcance.
And that's the reason why we do the outreach.
¿Y cómo hacemos el alcance?
How do we do the outreach?
Estamos visitando bibliotecas, parques, iglesias, paradas de buses, diferentes lugares.
So we're visiting parks, libraries, churches, bus stops, and different places.
Donde podamos encontrar trabajadoras del hogar.
Where we can find home workers.
Y sí, encontramos, en las bibliotecas encontramos muchas nannies, niñeras.
Yes, and we find them. At libraries, we find many nannies.
En los parques también.
As in parks.
Y en las paradas de buses, limpiadoras de casas. Y en los metros también, en las paradas.
And at bus stops, we found many home cleaners at the metros and
Llega-
at the bus stops.
Perdón. Llegamos hasta la persona y les entregamos los panfletos que tenemos hechos en inglés y español, donde les damos información y también las invitamos, si ellas permiten, a darnos su número de teléfono y su nombre.
So we reach out to them with these flyers, which are in English and Spanish, and we give them information. At the same time, if they wish, we invite them to give us their phone number and their name.
Si la trabajadora lo permite, nos concede
And if the worker allows it,
y podemos conversar en otra hora que no sea de trabajo.
we get their phone number and then we can talk at a different time that's not during their work hours.
En esta conversación, muchas trabajadoras adquieren confianza y nos cuentan sus dificultades y problemas del trabajo.
Through this conversation, we build trust and workers tell us about their issues and issues going on at work.
Y sí, estamos encontrando muchas trabajadoras que nos cuentan con lágrimas en los ojos
Yes, and we're finding many workers who tell us with tears in their eyes.
Tengo un caso que se presentó esta semana de una trabajadora que trabaja hace 2 años en una casa cuidando niños de 2 y 5 años.
For example, the case of a home worker, she's a woman, and she told me that she takes care of 2 children. Their ages are 2 and 5.
La familia toda viajó de vacaciones a Hawái
The whole family went on vacation to Hawaii.
y cuando volvieron estaban enfermos. Allá se contagiaron de COVID.
When they returned, they were sick. They had gotten COVID when they were away.
Y ella tuvo que ir a trabajar y cuidar de los 2 niños que estaban enfermos.
And she had to go to work and take care of the 2 kids who were sick.
Y pues ella también salió contagiada.
And of course, she also got COVID.
Cuando estuvo enferma, ella de hecho no fue a trabajar.
And she was sick. Of course, she wasn't able to go to work.
Y cuando ella, después de sana, volvió a trabajar, los jefes no le pagaron ni un día de trabajo que ella obtuvo su trabajo. Estuvo enferma.
And when she was healthy again, she went back to work, but she was not paid for any of the time when she was sick.
No la ayudaron con ningún medicamento, absolutamente nada. Y ella pregunta, ¿qué hago? Yo necesito pagar mi alquiler.
And they didn't help her with anything, none of the medicine. And she asked me, what can I do? I need to help pay for my rent.
Estamos haciendo alcance a las trabajadoras, pero pedimos también hacer un alcance con los empleadores, con los jefes.
So we're doing outreach with the workers, but we're also asking that outreach is done with the employers, with the bosses.
Para que ellos conozcan esta ley y también conozcan los derechos de las trabajadoras.
Because we want them to know about this law, and we also want them to know about the workers' rights.
Y que en los contratos de trabajo se especifique todos sus derechos. Gracias por esta oportunidad.
And that work contracts specify all of these rights. Thank you for this opportunity.
Thank you. Mr. Bonilla, we have one person in the Zoom who also needs translation.
Sure.
Do you want to provide her with any instruction about what would make that easier for you to facilitate before she begins?
That's a great idea.
Okay.
Thank you.
So that's Miss Angelica Maria Martinez de Rivera. And she should be able to hear us now if you want to provide any instruction.
Señora Martínez, mucho gusto. Mi nombre es Mateo, seré su intérprete para esta sesión. Únicamente le quisiera pedir para facilitar la comunicación si puede hablar en frases cortitas y me puede dar un espacio para interpretar lo que usted dice al inglés. Bueno.
Ok, está bien. Hola, buenos días. Mi nombre es Angélica María Martínez de Rivera.
Hello, good morning. My name is María Angélica Martínez de Rivera.
Soy un inmigrante del país de El Salvador y residente en DC por 6 años. Estoy aquí para urgirle el apoyar una enmienda crucial a la ley de acceso al idioma.
I am a migrant from El Salvador. I've been here for 6 years. I reside here in Washington, D.C., and I would like to urge you to support an amendment, an urgent amendment to the Law of Language Access of 2004.
Como miembro de la comunidad, he experimentado de primera mano las barreras lingüísticas al ir a solicitar una licencia al MBA.
As a member of the community, I've experimented firsthand some of the language barriers when I go to ask for a license, for example, to the DMV.
Tuve la mala experiencia por primera vez que fui a solicitarla, pues necesitaba un intérprete y les pedí ahí pues al personal que si me lo podían brindar, me dijeron de que no, no pude realizar lo que iba a hacer. Tuve que regresar por segunda vez, llevé a un amigo que me fuera a interpretar porque sabía de que no me lo iban a ceder y así pasó.
So I had a bad experience. I went to the DMV, I asked for a license, and I asked for an interpreter. They told me they couldn't give me an interpreter, so I had to go back a second time and bring my friend. That's what happened.
Pues otra parte también que he tenido una mala experiencia también es en los hospitales. Digamos, yo en marzo, 22 de marzo 2023, yo tuve un accidente laboral. Yo soy maestra de la primera infancia. Trabajo en un centro. Tuve una lesión en mi rodilla, pues lamentablemente,
Un momentito.
sí, ok.
Okay, so I had another bad experience, this time at a hospital. This was in March 2023. I had an accident. I am a teacher, an early childhood teacher, and I had an accident and I hurt my knee.
Pues tuve una lesión en mi rodilla. Lamentablemente nosotros las maestras tenemos un reglamento, ¿verdad? En los centros, entonces, pues a mí me tocó ese día, pues digamos de perder porque me lesioné. Yo iba con 20 niños a la calle con ellos. Tuve la lesión en mi rodilla derecha, se me reventó el menisco, entonces fui al hospital, necesitaba un intérprete. El médico me lo rechazó, no me quiso poner un intérprete.
Un momentito. Okay, so so there's a ruling at my place of work, and as I said, I had an issue with my knee. It's my right knee, and at the time I had to go out with 20 children. I had to go out to the street, and I had this knee issue. My meniscus had burst open, and I had to go to the hospital. I had the same issue where the hospital would not provide me an interpreter.
Pues el médico, el ortopeda que me estaba evaluando mis estudios, pues me lo negó y lamentablemente pues nosotros, como le repito, no conocemos nuestros derechos y lamentablemente cuando yo me di cuenta de que sí había una oficina de interpretación en el hospital, me llevé la gran sorpresa y nomás con lágrimas en mis ojos, pues me puse triste y dije yo, wow, lo que pasa. Y en ese momento no me quedó de otra que mi hija de 16 años y mi hija de 12 años me interpretara porque el médico me negó los derechos de un intérprete.
And the orthopedic doctor at the hospital, he denied me the interpreter. And, you know, we didn't know our rights. And there was, in fact, an office at the hospital, I learned later, and I was surprised where they had interpreters. And so I was sad. I had tears in my eyes. And I had to rely on my daughters, 16 and 12 years old, who could help me out with interpretation.
A veces, bueno, en mi opinión creo de que estamos pues viviendo tiempos muy difíciles porque digamos, estamos en un país en América que no debe de haber discriminación, digamos, ni por raza, ni por religión, porque es algo muy frustrante, se lo digo, porque me ha tocado también hoy que estoy sacando citas médicas. Hoy, hace como unas 2 semanas, tuve una cita o para que me hicieran un MRI en mi rodilla. Tuve que molestar a otra persona que me interpretara para que me sacara esa cita. Y es algo frustrante, digo yo, porque en todo lugar debe de haber un intérprete, aunque no sea presente, sino que
Un
también por
momentito.
línea. Okay.
Okay, and it's just my opinion that, this is really frustrating. At the time we're living, that people are still being discriminated because of race, because of religion. This is constantly source of frustration for me. 2 weeks ago, I wanted to get an appointment. I had to get an MRI, and I had to bother another person to help me with interpretation. And this is just constantly very frustrating.
Thank you very much for your testimony.
Muchas gracias por su testimonio.
Okay. Por eso apoyo el consejo pues de enmienda de que pueda pues acceder a la petición pues que estamos pidiendo. Gracias.
And this is why I want to give my support to the council so they will support the amendment that we're asking. Thank you.
Thank you. Commissioner Patel.
Good morning, Chairperson Nadeau. Thank you for holding this hearing so that we can enter our comments into the permanent record. My name is Tripti Patel. I am a third-term advisory ANC commissioner that represents single-member District 2A03, which is the historic Foggy Bottom. In addition to that, I'm DC's longest-serving elected official that is actually a current tipped worker. So I just want to give you a shout out. So thank you for standing with tip workers. A lot of us love you. I love you. So thank you for always standing with us and your show of solidarity and support. The reason why I am participating in this hearing is I do want to amplify and uplift the domestic workers ask for the emergency amendment. So I want to throw support behind that for them. I am coming here sadly to say that my experience with the Office of Human Rights has been very, very disappointing, actually heartbreaking. I actually thought my experience was isolating and alone until I came to this hearing, and I've heard several witnesses espouse the exact same thing. Last year, news writer Alex Como actually broke the story about a lot of the bullying and harassment on ANC 2A, which I have been a target of, along with my colleagues, Commissioner Yannicka Micton and Chairperson Jim Malek. And I initially went to the Office of Human Rights. I filed a complaint about the treatment I'd received from former Commissioner and Chairperson Jerry Epstein, as well as current Commissioner Joel Causey, about my treatment with them. And to even get a response from the Office of Human Rights, I had to ask then Chairperson Robert White for assistance in getting someone from OHR to return my phone call and even take my complaint. And as some of the people have echoed, it doesn't seem that the Office of Human Rights works with a sense of urgency. By the time I got a response and a ruling, even though it was like everything I could put on seemed questionable, they said that I had no merit. And it's almost kind of like Office of Human Rights says, we're here to help you, we're here to represent you, we're here to advocate for your rights. When you do utilize them, they don't seem to want to actually protect your rights or actually say, you know what happened to you has merit. It may not meet the legal guidelines. And right now I'm going through a bullying and harassment situation at my tipped worker position. While the bullying and harassment has not gone down in ANC 2A, it's still happening. The vitriol is still the same, but it feels that because there is no mechanism, no lever of power at all to end any of these things, like workplaces will get away with it, or elected official colleagues will get away with it. And it's just really, really frustrating when they say, well, Office of Human Rights is a lever or an arm you can use. And then when you reach out to them, they're not responsive. Or when they do respond, when you finally send them your case, they take at least a month and a half, which I guess is really good compared to what I'm hearing from other people to get back to you. I think it took like an average of like 4 to 6 months before, like from finish to start, before I had resolution on my case. And then by the time like they got back to me, I'd lost the ability to go to another legal entity to have my rights exercised. And I just really feel like this is a disappointing agency because of their mission statement of what they should be doing. And, the fact that there's so many people in here on this panel, in this hearing saying, hey, this agency isn't doing right by its residents and its citizens is really, really disappointing. It's really heartbreaking. So I'm hoping that as a result of today's hearing, OHR will take some concrete steps to actually be a better agency. I wouldn't like to see it go away, but I just want to see it function well and serve the people. Thank you, Councilwoman.
Thank you very much for your testimony, Commissioner. Next, we'll hear from Allison Miles-Lee, Bread for the City.
Great. Good morning, Chairperson Nadeau. My name is Allison Miles-Lee. I'm a managing attorney at Bread for the City. Many of our clients are limited and non-English proficient, including many immigrants, and rely on important government services to sustain themselves and their families. I also represent Bread for the City on the DC Language Access Coalition. Like Angelica, who just testified, and Nancy Leon, who testified earlier, I'm here today to stress the importance of passing legislation that will enable OHR to enforce the term of DC's critical language access law, the Language Access Act of 2004. As you know, the Council passed the groundbreaking Language Access Act to ensure that all district residents can access resources and services in the city, regardless of whether they speak English. The 2004 Act requires DC government agencies to provide interpretation in all languages and to translate vital documents into high-volume languages in order to serve limited and non-English proficient customers. However, the only way to enforce the 2004 Act is to file a language access complaint with OHR, which can result only in a finding of noncompliance. Agencies are then free to disregard OHR's findings. Over the past 5 years, OHR has made approximately 28 findings of noncompliance involving at least 14 different government agencies and contractors. The alleged violations are wide-ranging. Perhaps most egregiously, these OHR investigations also revealed several cases where agencies resorted to inappropriate ad hoc communication methods, such as using a child or fellow inmates in a prison to communicate with people instead of trained interpreters. There were also instances where agency staff engaged in disrespectful and humiliating behavior towards complainants on top of the language access violations. Bread for the City is extremely grateful for the leadership and commitment of OHR's Language Access Director, Rosa Carrillo, and her team, along with OHR Director Nin Kang. Our experience working with OHR's Language Access team stands in contrast to some of the testimony that I've heard today, flagging concerns about OHR's other discrimination complaint processes. With respect to language access complaints, we have seen OHR promptly launch investigations in a way that centers the limited and non-English proficient community members' experiences and results in thorough reports. However, OHR has no power to enforce the law by levying fines against non-compliant agencies and cannot provide relief to complainants who have suffered harm due to a language access violation. Often, agencies simply ignore corrective actions that are issued by OHR. To close this enforcement gap, Bread for the City and the Language Access Coalition have proposed what we call the Language Access Enforcement Act of 2024. This act would borrow from the successes of other DC non-discrimination laws by fining government agencies $2,500 each time that OHR finds they violated the law. We believe the threat or use of a fine will induce agencies to take seriously their obligations to develop language access policies, adequately train their staff, and provide interpretation and translation. When the DC Council enacted the Language Access Act nearly 20 years ago, it wanted to ensure DC's diverse community could access government services. However, the desired outcome is not being met. Limited and non-English proficient individuals continue to face the same denials of access over and over again. Amending the Act to give OHR additional powers to hold agencies accountable will help ensure that the original goals of the DC Council are met and that all individuals are able to access critical DC services. We thank you very much for your support, Councilmember Nadeau, and I welcome any questions.
Thank you very much for your testimony. We'll now hear from Sophia Balemian Spencer.
Good morning, Councilmember Nadeau and staff. Thank you for the opportunity to testify today. My name is Sophia Blemian Spencer, and I'm a workers' rights attorney at the Washington Lawyers Committee for Civil Rights and Urban Affairs. I'm also here today on behalf of the committee to urge the council to pass and fund the Language Access Enforcement Amendment. The amendment creates important fine structures that would hold DC government agencies accountable for violating the Language Access Act. The current law requires DC government agencies to provide equal access and participation in public services, programs, and activities for both limited and non-English proficient district residents. If an individual believes an agency has violated the law, they can make a language access complaint with OHR. OHR then determines whether the agency is in compliance with the law. However, beyond OHR issuing notices of noncompliance, there are no penalties for these agencies. Given the Act's current lackluster enforcement, DC agencies repeatedly failed to provide proper language services to district residents. Over the past 5 years, OHR has made 28 determinations of noncompliance involving various agencies, and 5 of these agencies have committed repeat violations with no additional penalties. The new amendment will create a fine structure. If OHR determines that an agency is not in compliance with the law, the complainant can receive up to $2,500. If an agency is found to have violated the Act 4 times within 1 year, it will trigger an OHR audit. It also requires OHR to offer the complainant an opportunity to participate in the corrective action process. And if the agency doesn't comply within 30 days, it gives the complainant the right to file a subsequent complaint based solely on the agency's failure to comply. The committee has seen how language barriers can prevent individuals from accessing the services they need, as well as how beneficial proper language access can be for these communities. While my written testimony addresses multiple clients, I'd like to highlight one of their stories here who couldn't be here today. Antonia Diaz de Sanchez moved from Guatemala to DC in 1999 and began working as a food truck vendor in 2016. As a Spanish speaker, Ms. Diaz de Sanchez experienced a variety of language access issues at both DLCP and OTR when trying to renew her vending license after it expired during the pandemic. On multiple occasions at both these agencies, she asked for a translator and was never provided with one. It was not until 2023 when I went with Ms. Diaz de Sanchez to these agencies and requested an interpreter did she receive one. Thanks to the interpreter, she learned that she had an outstanding balance on her account that prevented her from renewing her license because of DC's Clean Hands law. Ms. Diaz de Sanchez does receive translation service. When she does receive translation services over the phone, in person, and for documents, it helps her significantly. She can communicate in the language she understands, and the agencies are able to explain the intricacies of her tax and licensing accounts. The district is a hub for immigration, and the population is growing. Almost 15% of DC's population consists of immigrants, with top countries of origin including El Salvador, Ethiopia, and Mexico, all countries with languages other than English as their primary language. 30% of DC's population also identifies as a limited English proficient. Thus, we asked the council to both pass and fund the amendment that would create fines for agencies who violate the law. This would have a positive impact on how significant amount of district residents access the services they need. Thank you for support and your leadership on this amendment.
Thank you so very much for your testimony. So what we will do now, actually, Mr. Bonilla, I'm going to have you move aside. We'll put a chair right there so you can still translate for Q&A, but we'll bring Mr. Jairo Nunez from IUDA, Senior Language Access Coordinator. Sophia, you can stay if you want. We'll do some questions. We just want to make sure that all of our witnesses have seats and then perfect. That way you guys can share the microphone as we do questions. Thank you very much, everybody, for your flexibility as we transition back to in-person translation services. Okay, you may begin your testimony. Thank you.
Buenos dias. Good morning, Chairperson Nadeau and all the staff that support the work of the Committee of Public Works and Operations. My name is Jairo Nunez, and I am a member of the Language Access Program at IUDA. I also represent IUDA through my involvement with the DC Language Access Coalition. I want to thank you for the opportunity to come before you to testify in support of the Language Access Enforcement Act of 2024. 20 years ago, the district became a pioneer and a model for other cities across the country, committing to equity and inclusion through the protections found in the DC Language Access Act. With 20 years of experience under our belt and infrastructure around language access, this milestone can be used to reflect on what we can do better. I believe that the biggest issue we have today is that our neighbors that communicate in a language other than English continue to encounter language barriers when reaching out to covered entities with major public contact in the district, causing them to lose trust. These negative experiences cause individuals to pull away and become less involved. These individuals then share their experiences with their friends and family member, and that mistrust expands further out in the community. DC must continue to strive towards equity and to continuously remove language barriers so that there is a greater participation amongst all that call DC home. This will result in more opportunity-rich neighborhoods, successful businesses, and thriving people. On May 3rd, 2023, I had the privilege of participating in the Language Access Listening Lab session hosted by the Office of Human Rights at the Carlos Rosario International Public Charter School. During this session, I had the opportunity to hear from language access stakeholders about their experiences when they exercise, request, and learn about their language access rights in the district. On August 17th, 2023, I had the opportunity to engage with other language access stakeholders once again by facilitating a listening session that was hosted by the DC Language Access Coalition. The stories that were shared during these two sessions have various common themes. That one, acts of noncompliance are occurring at covered entities with major public contact at a much higher rate than what is being reported. Two, our neighbors are losing trust at an alarming rate and are becoming reluctant to engage with covered entities. And three, participants expressed concern over the nature of the interaction, that it seemed confrontational, that staff seemed annoyed, irritated, and even dismissive, all of which stems from covered entities having a reactionary response to language access. These harmful experiences stay with these individuals and influence their decision when thinking about whether or not to engage with a government agency in the future. Covered entities need to be motivated to develop effective language access policies and have better staff training. Covered entities that continuously fail to comply with the Language Access Act time and time again are the reason we need to emphasize enforcement with this amendment. Agencies need to take their obligation more seriously, and a fine structure would assist in that. Acts of noncompliance by one agency impacts us all. I have heard from leadership in DC Council, leaders from the Office of Human Rights, and other community leaders acknowledge that the complainants do not want to go to the formal complaint process because it is intimidating and time-consuming. OHR is not able to ensure compliance if incidents are not being reported. This issue needs immediate attention. I implore each of you to think about how different the experience is for someone simply based on the language that someone communicates in. To think about the burden that we place on our neighbors that communicate in a language other than English for something that should have been made available from the initial interaction. How these interactions and processes impact their day-to-day lives and the lives of their families. And so I ask the council support the Language Access Amendment Act of 2024 and to back it with funding through budget appropriations to help us rebuild trust with our neighbors by demonstrating our commitment to remaining a welcoming city that is safe and accessible to all. Prioritize language access in the budget as a matter of equity and justice. I want to express my gratitude to OHR's Language Access Director, Rosa Carrillo, and OHR Director, Nin Kane, and to the Council of the District of Columbia for your leadership and support in advocating for the rights and dignity of all who call DC home, regardless of their language background. Muchísimas gracias.
Thank you for your testimony. And thank you to our witnesses from IUDA, Washington Lawyers Committee, and Bread for the City. I'll start with you all. So what, and Ms. Milesley, you may, I suppose any of you can answer this. What are the current corrective actions that OHR can issue when they make a finding of noncompliance?
From what I know, there's no limitation on what corrective actions they can issue. Typically, it's things like retraining frontline staff, maybe assigning bilingual staff to certain centers. But the bottom line is the corrective actions are not enforceable. And so OHR can do whatever it wants. And they do follow up with agencies. And I think push and follow up to see if they've implemented the corrective actions, but there's simply nothing they can do if agencies don't.
Sure. And there's been some discussion about a proposal to update the law. So what would a fine structure look like? Who would benefit and how would that work? Anyone, any of the three of you are welcome to answer.
And people can jump in if I get anything wrong here, but generally it would be what we're proposing is a $2,500 fine to be paid by the agency to benefit the complainant. So, you know, it's time intensive to bring these complaints, to participate in investigations. We think that people should be compensated for that effort and then for the harm that was done to them. And also, I mean, our goal is not ultimately to enrich complainants, as some of these other laws that have passed with fine structures have shown over time. The number of complaints we imagine will go down as agencies start to prioritize funding language access, so that, you know, over time, there won't be as many complaints because they'll actually be providing language access.
And how did the proposal settle at 2,500? What's the significance of that number?
I think it was similar to the ban the box legislation that we were modeling this on. But if anyone else remembers exactly how we landed on that number,
Yeah,
feel
I'll
free to
kick
jump
it
in.
over to Mr. Nunez in case you want to say. Yeah.
No, I agree with Allison, and I believe Allison did mention in her testimony that this was a successful implementation through the ban the box.
Ban the box. Okay. And Ms. Bowman Spencer, is there anything you want to add?
No.
Okay. Thank you so much. Okay. And thank you also, Ms. Sandoval and Ms. Toricio. Ms. Toricio, oh, and Ms. Rivera. Ms. Toricio, you mentioned that you were working with the Office of the Attorney General. Could you say more about what your experience has been like?
Sí, cuando esta ley es aprobada, también tuvimos que estar casi todos los días acá pidiendo fondos para que la ley sea efectiva. Entonces, nosotros somos un equipo en DC que nos están facilitando todo el material y cómo transportarnos para llegar al mayor número posible de trabajadoras del hogar. Y sí, yo estoy muy sorprendida de encontrar en los diferentes, especialmente ahora que es época de invierno, en las bibliotecas, espacios donde están las nannies. Y, perdón, es que...
So when this law was approved, well, at this time during the process, we were asking for funds so that the law could be an effective law. And so I was part of the team in DC that was facilitating material for transportation because we wanted to get the largest possible number of workers, or home workers, out. And I was surprised to see that a lot of nannies were to be found at libraries.
Y veo mucha alegría de las trabajadoras al saber que ya hay una ley que nos va a proteger.
And I'm very happy to see that we have a law for workers to protect workers.
Hay muy buena acogida de todas ellas, con mucha curiosidad preguntan y quieren saber más.
And it's been very well received. They have a lot of curiosity and they want to know more.
Pero también hay preocupación porque dicen ellas, ¿y cómo pedimos un contrato de trabajo? De ahí el jefe me despide.
But they're also very worried. They want to know, how are we supposed to request a work contract? I might get fired by my boss.
Entonces, es por eso que estamos pidiendo que haya educación e información para los empleadores.
And that's because we're requesting that there's information and education for employers.
Hay muchísimas trabajadoras que necesitan conocer esta ley. Estamos llegando, pero hay mucho que hacer.
There's just so many workers that need to understand and know this law. There's a lot of work to do, but we're getting there.
Gracias.
Thank you.
Thank you very much for your testimony. Thank you very much to this panel. I appreciate you. Oh, yes.
Could I just share one more thing? Yeah.
Absolutely.
I just want to say thank you. Being able to witness how language access services were rendered during this hearing really makes a difference to see the participation that was able to be involved. I do feel that everyone here had an opportunity to fully participate. That's not something that we see often. And this goes beyond just what the statute says. And so I really appreciate your dedication to that.
Thank you. That's very kind of you. Thank you all very much. We'll now be joined by the Director of the Office of the Clean City, Phil Thomas. Have you, before you sit down, oh, yeah, Mr. Do you need it? We are here to provide that type of assistance. Okay. If you could raise your right hand, do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Wonderful. When you're ready, you may begin your testimony.
Good morning, Chairperson Nadeau, members, staff of the Committee of Public Works and Operations. My name is Phil Thomas, and I'm honored to serve as Director of the Mayor's Office of the Clean City, housed under the Mayor's Office of Community Affairs, led by Director Jackie Reyes, under the visionary leadership of Mayor Muriel Bowser. Thank you for the opportunity to testify today regarding the performance of Clean City in fiscal year 23. In FY23, Clean City continues a strong year of community partnerships, receiving more than 112 adopt-a-block applications, 89 of which were approved. The office coordinated 81 partner community cleanups and distributed 13,200 doggy bags to make the district the best city to live, work, and play. As the community links to district government, we act as the community voice in our government actions and works. Our office understands that through community and government connections, we can foster and develop meaningful relationships for all we serve. A trusted messenger, our office acts as the hub that works with the Department of Energy and Environment, the Department of Public Works, and the Department of Health, Rodent and Vector Division. Through the Mayor's Office of the Clean City, we build upon partnerships to engage the community, dispense information regarding the mayor's and administrative projects and initiatives, and attend engagement events like DPW Annual Truck Touch, ANC 4B Earth Day Resource Fair, City Ridge Earth Day event, and the annual Sustainability Fair. Our office continues to connect constituents to relevant information and critical resources and services necessary to keep them environmental friendly, safe, and healthy. This is especially true as we bring back downtown with more events and businesses. We would like to remind residents that DC is open, and we are ready to engage with visitors, residents who all want to enjoy our amazing city. The motto of MOCA is that we must meet people where they are, and Clean City does that by our signature events like Mayor Bowser's annual spring cleanup, this year happening on April 27th, our roll-off and e-cycling day, and our pet waste bag dispensary program in all 8 wards. Such engagements help keep closely connected to ensure that constituent issues and concerns are addressed, appropriate resources are introduced, and issues and required immediate actions are handled promptly. This connection also influences our problematic efforts and strengthens our outreach to the community. I want to highlight some events and programs Clean City has led and participated in FY23. On Friday, August 5th, Clean City partnered with DPW, the Mayor's Office of Asian and Pacific Islanders, MPD, and the Downtown Bid to do a Chinatown community cleanup and graffiti removal with over 70 volunteers came out and collected trash and removed graffiti on alleys, streets, and sidewalks. Over the course of FY24, we partnered with Safe Passage, the Office of Gun Violence and Prevention, the Office of Safety and Neighborhood Engagement to do community cleanups in neighborhoods in which they service. Last June, we worked with partners in Anacostia, Susan Quarters, Buena Vista, and Burview neighborhoods by doing a community cleanup with the violence interrupters. In FY23, under the Deputy Mayor of Operations and Infrastructures, our office was tasked to help lead the Fresh for Fall initiative, We did blitz communities and quarters, where we picked up leaves, collected trash, and collected bulk items. Working with our partners at DPW, Clean City organized a team of community ambassadors who placed over 98,000 leaf collection scheduled door hangers across all 8 wards, and hopefully, Councilmember, you received one. There you go. The ambassadors were able to engage directly with residents about upcoming schedule and provide real-time updates. Clean City is proud of our efforts to bridge the work of agencies, community partners to achieve a clean, healthy, and safe District of Columbia and a green, fair shot of all Washingtonians. For Clean City, serving and partnering with our community is an honor and privilege that I do not take lightly. The impactful work of our office, events, and programs, as I mentioned today, only scratches the surface of the work that takes place across all 8 wards. Clean City continues to serve as a central point of contact for goals that champion within the mayor's administration for preventing and reducing litter and trash population. In closing, I want to thank the mayor, Muriel Bowser, for her leadership and opportunity to serve in this capacity. It is an honor to serve my neighbors in our beautiful city in such a direct way. I also want to thank you, Councilmember Nadeau, and your colleagues for the opportunity to share the work of Clean City. On closing, I want to invite residents, community groups, and others who might be interested in joining or hosting a community cleanup by calling 202-727-6377 or emailing us at cleancity@dc.gov or visiting us online at communityaffairs.dc.gov/MOCC. Thanks for the opportunity to testify, and I welcome any questions.
Thank you so much. It is a pleasure to have you here. We are very excited to hear more on the record about the work of Clean City. So for the public, Director, please tell us the mission of your office.
The mission of our office is 3 points. It's the mayor's office of Clean City to bridge the work of agencies and community partners to achieve a clean, safe, and healthy District of Columbia with a green, fair shot of all Washingtonians. Serves as a central point of contact and goal champions within the mayor's administration by preventing and reducing litter and trash population with the District of Columbia, and pursuing purpose improvements and legislative agenda to strengthen existing laws, improving procedures and hospitality regulations and legislation proposed for supporting a Clean City plan.
Very good. And does your office partner with other federal agencies?
We partner, we take guidance from the EPA, but we do also partner with government agencies like Department of Public Works, Department of Energy and Environment, and Department of Health, Rodent Control, Rodent and Vector Unit Division.
And how often do you partner with other district agencies? What's that like? How does it look?
Yeah, so we partner with them once a month at least. As roll-off day is the next one is the 16th of March in Ward 8 at Bald Eagle Recreation Center. We just had one last week with last month, or this month actually, in Ward 3 at Chevy Chase Community Center with over 120 families attending. We collected enough bulk items for 2 roll-off bins, and it was a fantastic event.
That's great. Love it. And what's the work that you do with the DC Health Rat Vector team?
So when we get complaints from constituents about rodents or burrows in a community, we contact them directly and we go out on site to make sure that the rodents are eliminated.
Understood.
And I can give you an example. We worked with Commissioner Patterson over in the Brightwood community. And actually the news came out as well. And we had rodents squirming.
Okay. All right. So Clean City actually will go out with the rat abatement team then and do some of that work and sort of make sure, was it like a quality control kind of thing, or like more of a customer service thing, or?
It's both.
Yeah.
As requested, Clean City is not shy of going in the community.
Yeah.
And we are always in the community.
Do you do much with DPW's sweep team and the illegal dumping?
Oh, absolutely. So for the record, I used to work at DPW Sweep Division, working with their 301 and service requests And I'm very fond of that division as a former employee there. So we work very closely with them s- on issues pertaining to illegal dumping, especially with businesses around Ward 1. Especially we get complaints all the time around there. So we work very closely with it.
What's the advantage to being at the mayor's office of community affairs as opposed to, say, co-located with DPW?
There's a lot of benefits to that. First thing, as we all work for the mayor, it's good to be close to the mayor and get guidance from her and the mayor's office of community affairs. It also helps us, as we like to say, we are a on the ground in the community type of agency. It's good to be under the community affairs umbrella.
Very good. Your approved operating budget was $214,000 in FY23. Is that right?
That's correct.
Your office's budget is only visible to the public as a line item within the executive office of the mayor under the MOCA division. Do your operations incur expenses that are not accounted for in that line item?
So I like to say that the mayor's office of the Clean City is treated very, very well when it comes to the mayor's office of community affairs budget. We do have other expenses that come from the Department of Energy and Environment, as they provide us with the doggy bags for the dispensaries. They provide us with the trash bags. We have two types of trash bags. We have compostable ones, they're green, and then we have some black ones as well, the heavy duty ones. As residents like both of them, or particularly whichever one we like to give the resident what they prefer. But the pickers come from the mayor's office of community affairs.
Is that like the trash grabber?
Yeah.
Yeah, okay.
And we have some really nice ones. They fold and they're like on the go. You can.
Oh, nice.
Yeah.
So and those together, all those things make up the components of what, for example, you'd give to a neighborhood cleanup, or?
So it varies. When it comes to neighborhood cleanup, we always ask for, I would say, 4 line items when it comes to community cleanup. As we've done 81 of them this year, we ask for the individual's contact information, because we drop off the supplies to them and we pick them up. We ask them for the supplies, what supplies they're requesting. And we have rakes, we have pickers, we have trash bags, 2 types of trash bags. We have gloves, we have reusable gloves or unreusable gloves. We have dustpans, we have shovels. We have a lot of supplies.
Okay.
So we have to ask them what supplies they are requesting. And then we also like to know estimate a number of volunteers so we can give them the right number of supplies.
Great. So there is some confusion regarding the cleaning of dog waste. To your understanding, what agency or office is responsible for cleaning dog waste?
So I would like to say it falls under the mayor's office of the Clean City. There is a gray area on that. We did cite 4 individuals. We work with the Humane Rescue Alliance and cited 4 individuals when it comes to dog waste. That's if we have video or pictures of the resident and their pet. And then also we have a location we can locate them. And we did do that with 4 individuals, 2 in Ward 3, 1 in Ward 5. And I can't remember the other one as well. But we physically don't have the capacity to go out and pick up the dog waste.
Okay, so really nobody's responsible for picking up the dog waste except for the dog owner.
I would say the dog owner is responsible.
Yes.
So there is somebody that's responsible, and that goes
That's
to
the dog owner. So who actually writes the citation? Is that Humane Rescue Alliance?
That's correct.
Okay. That's interesting. And so there's an MOU with them.
Yes, that's
Okay.
correct.
And who provides the cleaning supplies? We've kind of gone over that. All right. I don't know. We have to, so your pre-hearing responses note that you received only 4 pet waste complaints in FY23. Is that just because people don't know to file them?
Yeah,
Because I've gotten more than that.
So it varies. So
Okay.
we get complaints through 311 through OUC.
So the 311 pet waste complaints go to you.
Correct.
Okay.
That's correct. But as you know, some people complain, they see dog waste. and they just want to complain to complain.
Mm-hmm.
So we need evidence of the individual whose pet it is. But what our office has done previously and still does is we are an engagement type of office, a community affairs office, and this is important that we fall under the community affairs umbrella. We will go out, if somebody complains about dog waste, we will go out, talk to all the neighbors on that block, give them a lanyard, a dog waste lanyard. It's blue. Sometimes it varies to green. So residents in that community know, and we give them information to pick up after their pet as well. It's called product picking up. It's a blue pamphlet as well. So we do community outreach when it comes to pet waste as well.
That's cool.
And neighbors really love that.
How many of those outreach efforts do you do?
So it varies on the complaint, how many 311 requests we get and how many neighbors we talk to. Once the neighbor files a 311 complaint, we reach out to that neighbor. Some of them just want to complain.
Yeah.
Some of them want action and we deliver that action. So
Okay.
so in Ward 5, in the Trinidad area, a neighbor has seen multiple pet waste. They said, what can we be done? We said we can do outreach, and we actually went out with that community member, knocked on the neighbor's door, handed them a lanyard information, and the neighbors really loved it. And the pet waste has stopped.
What do you do on a block with high rises?
So we usually reach out to, it's usually, what we find out when it comes to high rise is that the person reaching out lives in that high rise.
Mm-hmm.
So we usually give them the bags of the lanyards and information, and they distribute to those residents.
Okay. So only 4 of those complaints in FY23?
4 of those complaints have received a citation,
Got it. Okay.
if that makes sense.
Yeah.
They've been cited.
But you've many more complaints
Yeah,
than
absolutely,
that.
absolutely.
Got it.
We want to target the bad actors. That's what those 4 people are.
Could you discuss the Clear Communities and Waterways Initiative and how it's working?
Yeah, so that's I would say we work with the Department of Energy and Environment, and they probably would be the best agency
Okay.
to discuss that.
Okay. How do you think the work you do impacts our rivers?
So we do a cleanup in the Oxen Well area, and we go on the rivers and pick up trash. So I have a firsthand account of what the Mayor's Office of the Clean City does when it comes to waterways.
Yeah.
And I say we do a tremendous job.
What do you find when you're in the river cleaning up trash?
We find various things. We find shopping carts.
Mm-hmm.
We find bags of chips, and we find a lot of miscellaneous stuff as well.
What's the thing you see most? I mean, so it used to be plastic bags, and we got rid of that. Then it was straws, we got rid of those. So what do you see the most?
It depends on the area.
Yeah.
As if you report, we ask you when you do community cleanups to report what trash you collected.
Mm-hmm.
So we see bottle caps, we see gum, we see cigarette butts. It all depends on the neighborhood and the community.
Could we see the reports?
I have to check.
I'd
And
love to see the reports if you could get back to me.
yeah, I'll get back to you on that.
On the cleanups. I'm curious about bottles as well.
Okay.
Yeah, see what any data that we have as a government would be super helpful because we're trying to approach this through the committee as well.
Okay.
Thank you. How often does how does your office conduct outreach to communities most in need of rodent control education?
So we really work with our Mayor's Office of Community Affairs and Services as MOCRs. We really hear from them as they are the mayor's eyes and ears when it comes to the ward. And they attend ANC meetings, community, civic and citizens association meetings. So we really hear from them, but we also hear from residents as well. So when a resident reaches out, we follow up with the Department of Health Rodent and Vector Division, and we service that community members, that residents' needs.
And do you have a yearly or monthly target of number of households you want to reach for rodent control education?
We really work with the Department of Health, Rodent and Vector Unit when it comes to that. We do pass out flyers at events when it comes to the literature as well, but I would have to get back to you on the target.
And beyond education, do you have the option to do anything around rodent?
So we currently now we don't have the capacity under the mayor's office Clean City to do other outside of outreach. And that's where it stands.
How many are you on the team?
It's just two of us. I have a great associate director as well.
Yes.
Mhm.
Is your associate director here?
Yeah, she's behind me. Her name is Deja Pierre.
Wonderful. What would you need to evaluate whether targeted education is associated with a reduction in the rodent population in the immediate area?
I think I would have to talk to the Department of Health, Rodent Control, and Rodent and Victor Division and get back to you on that.
Now, you noted in your responses that you only received 2 requests for repair or replacement of NOD bins. Is that because the remainder are submitted to DPW directly?
Correct. And those were reached out to the Mayor's Office of Community Affairs and Services, which reached out to us.
Got it.
And those both were fixed rapidly.
Great. Are you authorized to proactively submit requests for residential bin repairs, or do you have to wait for a resident to request?
We prefer to work with the resident on getting it complete.
Yeah. Can you tell us a bit more about the Adopt a Block program? How many residents are a part of the program?
So when it comes to Adopt a Block, we had in FY 23, we had 112 Adopt a Block applications. The current number of Adopt a Block applications changes. As you know, it's a 2-year commitment. So depending on those 2 years of the individual, it changes. And 89 applications were approved this year. The reason why the others were not is because one was they try to adopt a block that's already adopted. They try to adopt a block in a commercial corridor. They try to adopt a block in a business improvement district, and they try to adopt a block in a main street that already has a clean team. So we reach out to those individuals who try to, or those organizations, it depends, who try to adopt a block, and we let them know that that we can't approve the application, but work with them on a residential street that's not adopted already.
Got to be a residential street, not covered.
Talk about it.
So what does it say if someone's trying to adopt a block that's already adopted? Is that kind of an indicator that the person who's currently adopted it isn't doing a good job?
No, not at all. It means that one is it means it can mean a lot of things, and I don't want to speculate on what it can mean. And I want to go on record on that. It can mean that the person who wanted to adopt the block is not engaged in the community. It could mean that that they didn't look at the current map and they didn't know that was already adopted. It could mean that the person who adopts the block isn't doing a good job of outreach. But what office really does is connect those two individuals.
Great. Can you talk more about what you do with the information submitted through the cleanup app and how you're able to track long-term or geographic trends?
Oh, yeah, absolutely. So once somebody records their community cleanup, we assess the data on what we find. Also, it helps us also when it comes to the commitment to adopt a block. The current commitment to adopt a block is 2 cleanups per year for 2 years. Most do more than that, and no one does less than that. So it just helps us, it gives a good data sense of what we're seeing.
And that's through the app?
That's through the app and the website as well.
Okay. Your responses say that Adopt a Block applications are not approved for any block covered by an existing clean team, or if it's a non-residential block. We just talked about that. Are Adopt a Block groups basically what we have in lieu of residential clean teams?
No, not at all. Clean teams are through like the main streets and other programs and through the bids as well. Community cleanups are through the community and the residents of the District of Columbia. And I think that's very important to say as residents, I would say they get a certain type of feeling when they clean the neighborhood.
What options does a resident have to request regular cleanups of their block if it's not covered by a clean team or an adopt a block group?
We ask them to adopt the block. We ask them to get engaged. We ask them to adopt the block. We ask them that to let us to reach out to us at cleancity@dc.gov, and we can follow up them with the supplies, and we'll bring it to them and pick them up, so they don't need to leave their house except to clean the block.
So, we have, in Ward 1 in particular, we have a lot of blocks that are pretty high traffic, right? They're adjacent to a commercial corridor, and they may have even as much trash as the commercial corridor, but clean teams don't service residential blocks, right? So you have sort of a conundrum there because, you know, you could use professional cleaning services on these blocks, and neighbors, even when they're trying to keep up, they just get frustrated. So one of the things I want to think about is what is a medium solution? What is a stopgap? I had tried 1 year funding clean teams to just go out an extra block, which sort of worked, but you know, they're just always stretched so thin that they can't keep up with it, even in their commercial corridors. So I mention it just so that we could spend some time thinking about it, you know, after today and working together on how we do that. We also have, you know, property owners in apartment buildings who don't feel responsibility for keeping the property clean in front of their building, despite the fact that is the responsibility of the property owner, because they feel, well, that litter's not coming from our tenants, right? So it shouldn't be ours. And sometimes there's some confusion there. So I may connect you with a particular resident I have in mind who does a lot of cleaning and may be convinced to adopt the block, or you may have some other ideas for him.
So I want to really brag on the mayor, Mayor Bowser, on what she's done and what she continues to do when it comes to the Fresh for Fall initiative. As she gathers Department of Public Works and agencies that fall under the deputy mayor of Denwa, and really goes out and blitz communities. As we saw, that was a big jump, a big cleanliness. As we did corridors as well as other high traffic areas. We send out DPW employees and Department of Building to take out trash, collect leaves, get bulk items out, spray the power wash the sidewalks, on top of what the main streets or the bids already do. And that was to help what you just said, those high traffic areas. So that I think the mayor has done a fabulous job. We're going to continue to do this. But then also when it comes to the adopt a block applicants, I know when applicants reach out to us and they want to adopt a block, and I can give you an example as well, on 9th and U Street, that's already has a main street that covers it. The Masons want to adopt that street. We asked them to go up a street as it's already covered by Main Street, and they said, "Look, can we also clean that U Street quarter as well?" And I said, "Go ahead." I said they would love
Clean whatever you want.
clean what and so on top of taking out trash on those corridors, the Masons go out and clean it as well.
Yeah, I mean, love that story. Love the Masons. They have an army of people, right? Like, I mean, if you need the Masons to volunteer, they will turn out like 300 people. And it's not quite the same as, say, a neighbor on a block who's frustrated by people littering. But I'd love it to be, right? Like, I'd love it to motivate everybody living in the high rises to come out. And some blocks are like that, but some blocks it's harder to engage. So, you know, maybe just figuring out how we can get that template to work for those blocks where we still have those challenges would be great. We can keep working on that. Can you tell us about the anti-littering campaigns your office has been involved in? I'm thinking of the Trash Free Initiative with Alice Ferguson. We had some great signs from them back in the day.
Oh, we still do.
Okay, you got more of them?
We ran out.
We've been running through our stash, so.
We ran out. We have about 4 or 5 that are in Spanish.
Okay,
We should hopefully, fingers crossed, that we should get some more don't litter signs by March.
Okay.
Around March time. As they go very quickly.
They do.
Through our office. But we found that even though a lot of residents want them, a lot of council members want them as well.
yeah,
Um,
to
and
give them to residents.
to give them to residents as
To
well.
be clear, we're not hoarding them.
But they go fast, and it's also a good social media tool as well. As we
Yeah.
found out, as we put it on our social media, we get a lot of retweets and a lot of people, a lot of comments.
People like them.
Oh yeah, they're fast.
I had one when I lived on a pretty busy block. I had one on my lawn. I actually found like
We still live on a pretty busy block.
I did. I moved to a slightly less busy block, but there was plenty of litter. So I found, and maybe it was all in my head, but I found when I put that sign up, I got less trash on my lawn. I don't know. Maybe it makes people think twice, but it's sometimes people need a reminder to act civilly.
Oh, they're
you know?
they're very effective, and
Yeah.
we seen that. And hopefully we distribute some more, hopefully soon.
Thank you. Your website lists a resource for Roll-Off Day 2024. You mentioned that earlier in your testimony. Can you tell us about this initiative?
Yes, and I want to point out that the last roll off of the year is in Ward 1. You know what that means, right?
We will have to show out is
You
what
have
it
to
means, I believe, if we're
Yes, and
continuing
it's
with
not
that
just roll
lingo.
off; it's e-cycle as well.
Okay.
It's a combined effort. Um,
Each one is?
yes,
Okay.
each one in each ward is
both.
e-cycling and roll off. The list was made public. The graphic should be made public today. And we just had one in Ward 1. Over 120 families attended. We actually started 30 minutes before, as we got word that Connecticut Avenue was about to shut down of the line. So we had to start it a little bit early. So our next one is in Ward 8, and the list is public on our website.
Okay. And what agencies do you partner with?
We partner with Department of Energy and Environment,
Mm-hmm.
the Department of Public Works.
Mm-hmm.
Those 2 agencies are the main proponent we partner with.
But why only one a month and one ward at a time? Because they're so great.
Because our office is also very busy doing community cleanups. Other weekends, we have to attend resources fairs. We also have other events as well. Like in March, we have a global, we have Women's Day of Service. One weekend, we have Roll-Off Day another weekend. And then the other 2 weekends, we have community cleanup. So it's
Does
very,
it have to be your office that does Roll-Off Day alone?
our office is we don't do roll-off alone.
Okay.
We do it with Department of Energy and Environment. We do it with Department of Public Works. Our office leads roll-off. And I would say that we will get there.
Okay. And how does your office conduct outreach to ensure communities are aware of the event?
So we work with the mayor's office. We work with the mayor's office of community affairs and services.
Mm-hmm.
Also want to point out, go back to reiterate, also we work with Departments of Aging and Community Living,
Mm-hmm.
also for roll-off days, as seniors reach out to
Mm-hmm.
our office or the Mokers, and we'll come to we won't come inside the house, but we'll come to the house, pick up the electronics or the bulk items.
And pick it and bring it over to the dumpster.
Talk
or
about it.
Yeah.
Talk about
Okay.
it.
So, and it's really just, okay, Roll-Off Day. Let's make sure everybody understands this is a day for people to bring their bulk trash to the dumpster or bring their e-waste.
Correct.
Okay. And how many staff are at Roll-Off Day?
So it's 4 hours. Me and my associate director, Deja Pierre, the 2 Mokers from the Mayor's Office of Community Relations and Services.
Mhm.
And then we have some surprise guests who always come by, like council members.
Surprise guests. Yes. Well, council members don't strike me as useful guests, but understood.
Well, I would say council members and others, residents, directors all come by and drop off bulk items.
That sounds great. Okay. We'll get the Ward 1 on the Ward 1 on the calendar. Anything else you want to highlight for the committee?
The excellent work our office is doing, not just roll off, not just community cleanups, but also with pet waste as well. Rodents, our office is very busy, and we continue to do the great work of the Mayor Bowser.
Thank you very much for your testimony.
Thank you.
All right, we are going to move to the next portion of the hearing. We're going to take a 5-minute break and resume at 11:55 with our Chair of the Human Rights Commission, Motoko Aizawa. And you are welcome to make yourself comfortable or take the break, whichever you prefer, but we will resume at 11:55. Thank you. Madam Chair, if you could raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
You may begin your testimony. Thank you.
Thank you. Good morning, or I guess good day. Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations. My name is Motoko Aizawa, Acting Chair of the District of Columbia's Commission on Human Rights. Thank you for this opportunity to discuss the activities and accomplishments of the Commission in fiscal year 2023 and fiscal year 2024 to date. The Commission is a quasi-independent administrative body that is affiliated with the Office of Human Rights, or the OHR. The Commission's primary role is to adjudicate cases under the DC Human Rights Act. For this purpose, the Commission consists of up to 15 commissioners who are appointed by the mayor and confirmed by the DC Council, and the administrative law judges, or ALJs, who are employed by the OHR. Currently, there are 10 commissioners and 5 vacancies. The Commission is working with the Mayor's Office of Talent and Appointments to identify candidates to be interviewed for the vacancies, and we hope to reach a full roster of 15 commissioners within the current fiscal year, barring a lack of candidates, resignations, and other changes. As you know, the OHR and the Commission provide administrative relief for violations of civil rights laws that occur in the district. This begins with a complaint, which is mediated, investigated, and if applicable, conciliated by the OHR. There are 2 types of cases. 1, public sector cases, which are filed against the DC government, and 2, private sector cases filed against non-government entities. The former cases are adjudicated by the ALJs, whereas in the latter cases, if the OHR finds probable cause for discrimination following investigation and conciliation has failed, the case is certified for a public hearing on the merits before the Commission. The Commission is currently supported by 2 ALJs, with Chief ALJ Erica Pearson directing the day-to-day activities and responsible for tracking and managing the Commission's case docket. They preside over the Private Sector Human Rights Act cases as well as ban-the-box cases once they have been certified by the OHR for a hearing. Before proceeding to full evidentiary hearing, the ALJs issue a scheduling order under which the parties are allowed to exchange discovery, and motions for summary judgment are considered after discovery has concluded. The presiding ALJ then conducts a full hearing, much like a trial, where the parties are afforded opportunities to present their evidence, including witnesses. Once the full hearing is completed, the ALJ assigned to the case will request a tribunal of 3 commissioners to review the case and a final order prepared by the ALJ. The tribunal then meets to discuss the case and either adopts, amends, or rejects the order proposed by the ALJ. Once the decision is finalized, it is issued to the parties. The Commission meets bi-monthly to be briefed on developments, including status reports on cases pending with the Commission, updates from the OHR and various committees, and any other activities undertaken by the Commission. We periodically receive training to stay updated on changes in relevant DC laws and regulations and other relevant development. In addition to this adjudication role, the Commission has another important role, which is one of education and outreach to help raise people's awareness of the benefits of the DC Human Rights Act. I will now turn to our key achievements from FY23 and FY24 to date. First, with regard to ensuring efficient and effective operation of the tribunals, notwithstanding the resignation of 5 commissioners, the Commission discharged its adjudication role at about the same rate as in FY22, meaning the Commission closed 13 cases in FY23, the same number of cases closed in FY22. We're glad to report that we closed 2 of the longest outstanding cases in FY23, which were certified in 2015 and 2018 respectively. On another note, 75% of the mediation attempts have been successful due to the tireless efforts of the ALJs. Altogether, cases took 19.5 months to be closed in FY23. We onboarded 3 new commissioners in FY23. They have received full training from the chief, administrative law judge, and others, and were integrated into the commission quickly. So that tribunals take place punctually with the full engagement of prepared commissioners, we have agreed that each commissioner will enter into a commissioner agreement that outlines the expectations for commissioner conduct when participating in tribunals. The agreement merely codifies our current practice, but it serves as a useful reminder of the key protocols for existing commissioners and provides new commissioners with a sense of time commitment required for tribunals. The full agreement will be signed in FY24 by existing commissioners, and going forward, new commissioners who join will be asked to sign it as part of their onboarding process. In FY23, the Awards Committee had another successful year. This year's Human Rights Awards ceremony, held on December 7, 2023, focused on disability, since disability is the 3rd most common basis for discrimination complaints, following race and gender. Our event was organized under the banner of protecting and celebrating bodies and minds of all abilities. And the Commission enjoyed partnering with 3 relevant DC agencies: the Office of Disability Rights, the Mayor's Office of Deaf, Deafblind, and Hard of Hearing, and the Department of Behavioral Health, in addition to close collaboration with the OHR. The Commission's main Human Rights Award, the Cornelius Neal Alexander Humanitarian Award, went to Tony Brunswick of Art Enables, the district's only art gallery and studio solely dedicated to amplifying the careers of artists with disabilities. Approximately 100 participants attended the event. The Rules Committee efforts were temporarily suspended in FY23 due to OHR's limited resources. The Outreach Committee contributed to the organization of the Human Rights Awards ceremony. However, going forward, the Commission and the Outreach Committee can benefit from a more systematic planning process so that our outreach and educational activities are sustained throughout the year. Our case digitization project made a little progress due to lack of resources. Moving on to our priorities for FY24, the Commission will continue to focus on adjudication as well as education and outreach to the community. Our first priority continues to be moving cases to closure. We expect the tribunals will operate efficiently and effectively with the benefit of the Commissioner Agreement and the rotation system that was put in place in FY23. As a matter of priority, we will endeavor to fill the vacancies so that the Commission can operate at a close to full capacity as possible and be responsive to caseload, as well as ensure the sound operation of the 3 committees. In addition, the ALJs will continue to offer mediation as well as fillable forms and other improvements to help complainants, especially the pro se complainants. The Commission, through the Rules Committee, will endeavor, again, to take up the revision of the procedural rules in Chapter 4 of the DC Municipal Rules in collaboration with the OHR. With respect to our rules, please note the Commission's concerns regarding the Fairness and Human Rights Administration Act, as noted in our responses to the oversight hearing questions. Specifically, we were taken aback by the bill's provision that would have the impact of taking the cases heard by the Commission outside the realm of contested cases under the Administrative Procedure Act, thereby significantly diluting the hearing process, delaying finality for litigants, and leaving the respondent without a symmetrical procedure. With respect to our education and outreach efforts, The commission hopes to re-examine the operation and activities of the Outreach Committee and implement new activities in FY24 under a new leadership. The Awards Committee will be gearing up planning for this year's Human Rights Awards ceremony to ensure yet another successful event. With regard to digitization of past cases, subject to availability of a dedicated intern or a contractor to be made available by the OHR, the Commission hopes to make progress in FY24, starting with an audit of available record for the period between 2013 to 2018 to identify what may be available for digitization and how to digitize them in a cost-effective way. Many of these planned commission activities that I just described are made possible through the excellence, dedication, and persistence of the ALJs, for which the commissioners are deeply thankful. Recently, the Commission has reached an amicable agreement with the OHR concerning the ALJ's job satisfaction and retention issues. The Commission hopes that the OHR will take note of the salary discrepancies and take appropriate action to ensure fair compensation for the ALJs. To relieve ALJs of their administrative burden, the Commission will take on additional record-keeping, onboarding, internal communication, and other administrative responsibilities. Finally, the OHR has also offered to explore additional human resources, such as contractors and law clerks, to ease the pressure on ALJ's caseload management. In closing, the Commission is already implementing our FY24 priorities and look forward to a close collaboration with the OHR with the promotion and advancement of the district's non-discrimination standards under Human Rights Act. We appreciate the opportunity to share our accomplishments and plans for continuous improvement and look forward to your advice and guidance. Thank you for your attention, and I am available to answer any questions you may have.
Thank you so very much for your testimony. You mentioned in your testimony that you have 5 commissioner vacancies. Was there a stated reason for their resignations?
It varies from commissioner to commissioner. Some have gotten new jobs and moved on. Some have decided that they have different priorities. So I believe none of the resignation has to do with dissatisfaction with being on the commission as such. But their circumstances have changed and they have to move on.
And what would the timeline be for filling them vacancies?
It does take a while because we rely on MOTA for suggestions of candidates, and then we go through an interview process. And that itself isn't that time consuming, but then the confirmation hearing and that public process does take time. So it does, I think on average, take a few months, up to 6 months for new commissioners to come on board.
What are you looking for? Just let's do a public service announcement here. What are you looking for in a new commissioner, and what's the time commitment? What qualities should we be considering in case anyone at home has some suggestions?
Thank you. So people usually assume that they have to be lawyers in order to be on the commission, and that is not the case, although legal training is helpful. In fact, I would say that diverse background of people from medical or psychological or educational or any other training are usually welcome because they bring this diversity of views in the commission. So there isn't any formal requirement other than for people to be curious and interested in our process and be available to dedicate the time. So the time demands mainly come from people having to be on tribunals. As you know, the tribunals are formed on rotational basis, so people are not on tribunals constantly. And the more commissioners we have, the longer the period it is between tribunals. But it does take time to read files and pleadings of various cases. It does take time to read the proposed judgments, final orders. It does take time for the commissioners to be on the tribunal and confer. So that is so I cannot say how much time per se, but people need to be able to be available. Now, if there is a work commitment, a conflict, people can opt out so that they can be on the next tribunal available. So we're not asking for anything unreasonable. Commissioners also need to attend our bi-monthly meetings. That only happens 6 times a year, so that is not a terribly demanding thing. But they're also asked to participate in training and are asked to participate in committee activities. So eventually these things, although separately, they're not time-consuming, time does add up. But I think the crux of the matter is that we welcome people from all backgrounds and all persuasions, and that diversity is extremely welcome. Thank you.
Wonderful. Thank you so much. How has the rotation schedule for tribunal assignments affected the workload distribution among commissioners?
It has worked very well. It gives the ALJs the foreseeability of who is going to be on the next tribunals. We're given heads up that we're next, and we can opt out if necessary. So I would say that that is a far superior process than people having to opt in to tribunals.
Yeah, sounds great. And you talked about the commissioner agreements. How does, can you explain what's in what the agreement is and how it helps ensure consistency and fairness?
Yes. Well, the idea is to make sure that commissioners are prepared and are present for meetings, right? And so it has anything from how much notice they are supposed to provide if they're not available, how to read cases that are on the case management system, the requirement to be available for tribunals on time, what they need to do following the tribunal meetings in terms of signing the final orders so that they are dispatched timely. They're pretty basic things, but they add up. And instead of the ALJ or myself having to repeat these things to everybody, we thought it just would be far more time efficient to have these things in one place.
And what's the training composed of?
We do have a commissioner manual, which is a very comprehensive manual. So we go through that, and there is no particular mystery about that. But also new commissioners get trained on the DC Human Rights Act, the kinds of cases that come through, the 23 protected traits. And we are in the midst of arranging all commissioners to go through the 23 protected traits training so that that would ease their understanding of cases when they go through the tribunals, as much as when they go through, go to public outreach events, that they are able to field some questions from the members of the public.
Thank you. To enhance rules and procedures for rights protection, the Commission plans to review municipal regulations and digitize past cases, as you mentioned. How does the Commission plan to prioritize areas for review within the municipal regulations?
Yes, thank you for that question. I've been on this commission since 2012, and as far as I can remember, the commission has always has been aspiring to amend the rules because there are lots of terminologies that are not clear. There are things that are outdated. There are perhaps some statements that should be there considering our practices today. And I think what happens every year is that there are some emergency things, emergency rule changes that are required. And so those emergencies take precedence over our comprehensive review of the rules. And in the past, the commission has carried out such comprehensive reviews, but never been able to move forward with proposing, well, first of all, prioritizing and proposing what should be amended. And so we'd like to resume that, take up where the last efforts have left off and to prioritize. So we're not going to propose a wholesale amendments, but there are certain things that we encounter time and time again that we would like to prioritize.
And how will it be different this time?
How would it be different this time?
As in,
Well-
it's always been by the wayside because of the emergency rulemaking.
Well, that is a fair question. I'd like to say this particular committee is extremely well qualified with lawyers. And I think they have been very aware of because these people have dealt with the rules from different aspects outside of the commission. And so I'm very confident that they are able to bring their perspectives into the work. And I'm not saying that we're going to accomplish miracles. We're going to go at it bit by bit, but we should be smart about prioritization and be clear about what those areas are and be focused about it.
And are you currently seeking an intern or contractor to do the digitization work?
Yes, that's a difficult word to pronounce. So that is my understanding from the OHR that funds will be available. And so this is something that we have to move on and to create terms of reference and to price things out. But as you know, Madam Chair, this is something that is very important to me, and I would like to see it through.
Very good. Thank you. How does the commission plan to evaluate the effectiveness of its outreach programs in promoting awareness of the DC Human Rights Act?
Yes, we are fairly modest about our ambitions here just because we could be doing so much more, and we're not doing that. So our approach so far had been to show up where OHR is organizing outreach activities such as hearing labs and other thematic meetings, and to be there as the sort of the embodiment of the other part of the commission or the adjudication process, right? That people like to see our faces, that their faces behind this adjudication process. And so just to be there, to be able to provide our perspectives. And that's what we have done. What we'd like to do going forward that we have been talking about is to focus on some venues where people are available to hear our messages. So libraries and ANC meetings and schools and universities and possibly other places where we can reach out and spread the benefit, basically, of the DC Human Rights Act. And that sounds quite ambitious, but I think if we systematize this outreach, and if we spread out, I think we can start to do a bit more than what we have been doing. So what we need to do, I think, is for the Outreach Committee, which is under new leadership, to think about what the systematization looks like and what kind of resources are available inside the commission as well as outside to partner and to start to get out in the public.
Wonderful. Thank you so much. In the July 11th, 2023 bi-monthly meeting notes, which was attachment B, there was a discussion initiated that one of the ways which commissioners can support outreach efforts is doing presentations for local ANCs and civic associations. And she also mentioned coordinating with Main Street organizations. Sounds like a great idea. Has there been any update on that?
So there has not.
Okay.
In part because a lot of commissioners felt uncomfortable being out there
Okay.
to field questions from people who may eventually file complaints.
Mm,
And so as not to direct them in the wrong direction in terms of legal merits or demerits of their complaints, a lot of commissioners wanted to get trained on the 23 traits training first. And that training was kind of difficult to schedule for scheduling reasons and so on. We are hoping to have this training conducted by OHR, and we're very grateful for OHR resources to be able to do this in the next coming weeks. And that hopefully will give Commissioner a little more confidence to be able to go out in the public to say who we are, what we do, without misguiding potential complainants.
great, thank you. Upgrades to the case management system and successive mediation services seem to be crucial for efficient case management, according to your responses. Can you elaborate on the upgrades made to the case management system in FY23?
Yes, so Madam Chair, I should have said that our Chief ALJ, Erica Pearson, is on medical leave.
Okay.
And as a result, there are certain questions that I won't be able to answer, but we will get back to you in writing. Having said that, perhaps Director Kine might be able to shed light on the case management system. I have to say the management system works well. It is an incredible tool as far as I'm concerned, that we can sit at the comfort of our homes and review cases as opposed to having, cases, paper files being sent to us by courier and to go through paper. And it makes retrieval extremely easy. So it is a matter of cost.
Mhm.
And I think that you will get more insight into this later. And
Great.
the other question on mediation,
Mhm.
well, I can say that the ALJs offer mediation to every single case that is certified. And as my statement said, they have had 75% chance of success, which I think is tremendous. And the intent is to carry on what we have been doing.
Great. The proposed Fairness and Human Rights Administration Act has some implications for the Commission's operations and the rights of litigants. One of them is to allow the Commission to award punitive damages in private sector cases. Could you talk about how this would impact the Commission's work or the rights of complainants in private sector cases?
Thank you for that question. And I should just make clear that we are in support of the proposal overall, except for that one aspect that I have proposed.
Understood.
And we are totally in favor of punitive damages.
Great, thank you. And you did mention reservations about certain provisions and the potential impact on the Commission's adjudicatory role. Could you say more about the specific concerns, and has the Commission engaged with stakeholders and advocacy efforts around the proposed changes?
As my statement mentioned, we are, well, I could go back to that. We are one small contribution to DC Home Rule, right? And we are a collection of DC citizens who are available to weigh in on human rights discrimination in the city. And so we are here as volunteers to serve on this commission. Actually, the ALJs go through an incredible process of discovery and hearing and scheduling. And as discoveries get more complicated and papers filed are more voluminous, and there are motions after motions after motions, they go through an incredible process. So we think that the value of what they provide in the adjudicatory process should be recognized, right? And what this act might do in terms of the process that we go through. So that's one thing. We also think that the proposal will simply extend the finality of the complainant's case because beyond DC Superior Court's process, there's appeal process also available. And as a result, we think that that is not necessarily in favor of complainants. And we also note that this is not necessarily a symmetrical procedure that is different from complainants to respondents. And not that we are here to take sides of respondents, but we are proud of the due process and the procedural fairness in the DC Human Rights Act, and therefore we bring that up.
Is there any compromise on this measure?
I believe there is.
Mhm.
I don't think it's really for me to state
Okay.
this publicly at this point,
Okay.
but we would love to have an engagement if there is still time.
Okay. Thank you. Can you discuss the distribution of cases across different categories of alleged discrimination? For instance, why were there no cases related to public accommodations during the period that our questions covered?
I don't know why, because we usually have quite a lot.
Okay.
And I personally have seen quite a lot of those, but it just so happens this year in this cycle, we do not have them.
Okay.
I don't think that there is any mystery behind it.
Feels like a mystery. Okay. How does the commission prioritize its resources and efforts to address cases across different categories of discrimination?
Prioritize
The different
resources.
cases across different categories. So for example, you know, are there certain if there's certain categories where there are more, is there a different level of prioritization in those categories of ALJs or commissioners or?
I don't think there is any prioritization. I mean, to the extent OHR certifies cases,
Yeah.
that the cases just go through the linear process. And so there is no prioritization.
Okay. And what outreach or prevention initiatives is the commission undertaking to address systemic discrimination in housing cases?
There isn't anything targeted to that particular category per se. I have been to several public meetings on the topic. There was a listening lab on housing and voucher holders that I participated in. I learned a lot. It is extremely insightful. And again, I think having a commissioner available at those meetings is helpful,
Mhm.
although there's nothing per se that we could do to advocate on those issues.
I see that in FY '23 through the first quarter of FY '24, the commission closed 13 cases. However, none of the commission cases substantiated an allegation of an unlawful discriminatory practice. What is required to substantiate such an allegation?
I might just ask our chief ALJ to provide her perspective
Sure.
on that.
Absolutely can follow up
Yes.
with that.
I do think that the legal bar is high, but I think I should just let her inform you.
That's no problem. Thank you. The commission discussed its case against aging rates, highlighting the challenges in meeting closure standards and addressing overage rates, particularly in quarters where they exceed the target standard of less than 10%. What measures is the commission taking to address the overage rates, particularly in quarters where they exceed the target standard?
So part of the problems we have been dealing with are those two cases that I mentioned, cases that were certified in 2015 and 2018, which weigh down the average. And as a result, we were extremely focused in closing those last year. And going forward and having been rid of those very difficult burdens, I think that our performance would be far better going forward. But I have to also say that delays are inevitable because cases get more and more complicated with more complicated discoveries, more papers filed, just because the process in some cases is quite professionalized,
Mhm.
right? And that, I think, weighs down on the process as far as the time is concerned. And so it's not that our ALJs are sitting around and just twiddling their thumbs, but it's just the nature of the cases and the litigation process that gets more and more complicated as we go along.
Your pre-hearing responses discuss delays caused by discovery processes. So we just talked about that. Requests for continuances and extensions of time from attorneys and representing the parties. I was going to ask how the commission plans to mitigate the delays, but I wonder if those delays are important to the process.
Yes, so there is one proposal that we have, which is buried in the statement, which is the commission orders
Mhm.
that we are going to experiment on this year. And that will address, for example, page limitations in papers. So that
Interesting.
they don't go on and on and on. I think that is a fair point. I don't think that that would prejudice anybody's rights. So there are certain things that I think we can do, and we will be tackling those in this fiscal year.
Interesting. So kind of more of a best practices sort of thing?
Yes, and I think overall, there are places where we could trim time, just so that things move along.
Okay. Regarding the collaboration with OHR for digitizing past cases, what challenges were encountered in FY23 and how are they being addressed in FY24?
Well, I would say that the issue is primarily a budget issue.
Okay.
Right?
Yeah.
I think that we are in agreement with OHR that this really is preferable to move forward. It's just that OHR had various competing priorities and the budget was not available. So I think that
You think it is now for FY24 based on your prior answer?
this is my understanding from
Okay.
OHR. You might want to ask Director Khan.
We have the people in the room, so we can get to that. Thank you. And I think I'll leave it there. Thank you very much for your testimony.
Thank you for your time and attention.
And we'll now be joined by Director of the Office of Human Rights, Nin Kine. Before you begin your testimony, we'll have you, once you get settled here, have you take the oath. Thank you. Oh, yes, anyone else who might be joining you for testimony will swear at the same time. Oh, so we can promote her. Great. Well, that's good because we couldn't have fit one more body at this table. Yeah, it's fine. We're going to promote her too. We'll swear you all at once. So. Oh yeah, she needs to accept the invitation. Uh-oh, she declined. Maybe we caught her at a bad moment. Let's try again. Got her? Cool. Okay. I don't know yeah. Okay, and then if you could, yes, if she could turn her video on and raise her right hand as well, that would be great. Ms. Dean, can you turn your video on, please?
I'm coming. It's trying to connect.
Oh, okay.
It won't allow me to turn video on. I'm blocked from turning it on. There we go.
Are you logged in a couple ways? Because we promoted you, so you should be able to control.
Yeah, I see your the message comes up and I click it, but it still doesn't allow me to show the video.
Something's happening. It might be your computer
I
because
think it may be coming now.
okay.
Make sure the video.
That's your audio. Okay. Well, it may be your computer because it looks like your camera is technically on. And maybe there's a, but we can't see you.
Sure. We're in the process of moving, so it could be
Oh dear.
something that was-
Okay, so just if you could loudly affirm after the statement, we'll work
Yes,
with this.
ma'am.
Okay. Everybody raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
Great. We're going to mute you, or you can mute yourself now, and we'll come back to you as needed. I know. And Director, you can begin your testimony. Thank you.
Thank you. Good afternoon, Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations. I'm Nin Kine, Director of the District of Columbia's Office of Human Rights. Thank you for inviting me to discuss the activities and accomplishments of OHR in fiscal year 2023 and fiscal year 2024 to date. OHR is the district's quasi-judicial agency that works to eradicate discrimination, increase equal opportunity, and protect the human rights of individuals in employment, housing, education, public accommodation, and government services. We do this by enforcing local and federal civil rights laws through a cost-free legal service to those who believe they have experienced discrimination, and by taking proactive measures through education and community engagement. Our enforcement process is a two-part process in which we begin with an investigation, and if the investigation record supports a probable cause to believe discrimination may have occurred, we certify the case for an evidentiary hearing where both parties are afforded the opportunity to present witnesses and submit evidence. In private sector cases, our lawyers prosecute the cases alongside complainants. As of this moment, OHR enforces approximately 23 anti-discrimination and compliance laws. The newest in FY23 and 24 include the Sexual Harassment Data Collection Act, the Domestic Worker Employment Rights Amendment Act, the Human Rights Enhancement Amendment Act, and the Eviction Record Sealing and Fairness in Renting Act. Others law include the DC Family Medical Leave Act, the DC Parental Leave Act, parts of the Universal Paid Leave Amendment Act, the Unemployed Anti-Discrimination Act, the Fair Credit and Employment Act, the Protecting Pregnant Workers Fairness Act, the Employment Protections for Victims of Domestic Violence, Sexual Offenses, Stalking Amendment Act, the Fair Criminal Record Screening Amendment Act, also known as Ban the Box, the Fair Criminal Record Screening for Housing Act, the Tipped Wage Workers Fairness Act, the Racial Equity Achieves Results Act, the Care for LGBTQ Seniors and Seniors with HIV Amendment Act, the Youth Bullying Prevention Act, and the DC Language Access Act. Of course, OHR was established by and enforces the DC Human Rights Act. Over the last decade, the Human Rights Act has significantly evolved and now covers 23 protected traits across our enforcement areas, making the district one of the most progressive jurisdictions in the nation, and we are certainly proud to have that honor. In FY23, the Act was further expanded to include a broadened definition of harassment, explicit addition of contractors, and this year, removal of domestic workers from exclusion of the Act's coverage. As you know, at present, there is also pending legislation revising the Human Rights Act.
In addition to these local laws, OHR works with our federal counterparts to enforce Titles 7 and 8 of the Civil Rights Act, the Age Discrimination in Employment Act, the Americans with Disabilities Act, and the new federal Pregnant Workers Fairness Act. With these numerous laws on the books, OHR's proactive arm works thoughtfully and diligently to educate our community. We use a tailored approach to this statutory mandate. For example, in addition to our regular training programs for the public and district agencies, which we offer several times a year in person and hybrid, we hold office hours at community libraries, partner with sister agencies and community organizations to table at events, produce written fact sheets and guidance documents. Additionally, we work to publish reports such as the agency annual report, the language access report, the youth bullying prevention report. New in FY23, we worked with the Office of Racial Equity to develop and produce training and guidance materials for advancing racial equity in DC, including our inclusive language guide. And in FY24, we are publishing the sexual harassment data collection report. I will now turn to OHR's key achievements, starting with our operational developments, the impact of those developments in our enforcement work, then continue to programmatic accomplishments and community engagement efforts. As stated in last year's testimony, in FY23, one of our priorities was to invest in our people, which meant expanding our recruiting and hiring efforts and establishing retention tools. And I'm so proud to report we accomplished these goals. OHR filled 17 vacancies, including 4 hard-to-fill senior leadership positions. In order to provide a career ladder and retain qualified employees, OHR promoted 10 employees to higher level positions. OHR also expanded its recruitment efforts to district residents by attending 7 local career fairs, including those east of the river. Finally, for the first time in OHR's recent history, the agency held a staff retreat that included an employee recognition component. In FY24 to date, OHR currently has 5 vacancies, which represents a vacancy rate of 7%. This is the lowest rate the agency has experienced in the past few years. OHR is currently on track to fill all of these existing agencies by the end of the fiscal year, if not earlier. In FY23, OHR modified its organizational structure to include an additional tier of management. This new tier of senior managers is designed to oversee the different units within the agency and includes the following positions: Chief Administrative Officer, Senior Advisor to the Director, Associate Director for Enforcement, Associate Director for Communication and Equity Programs, and the General Counsel, all of whom I think you'll see in the room today. These changes help the agency gain more oversight, thereby more efficiently meeting its deliverables and providing much needed support to its growing staff. Another priority OHR set out in FY23 was to retain an IT specialist and a data specialist. And again, I'm very proud to share we were able to do we were able to retain both these individuals with the support of our mayor and deputy mayor. The IT specialist started in September, and the data analyst soon followed in December. These individuals already have had an impact on the agency's operations, including a smoother new employee onboarding process, technology fixes and updates, progress on our case management system improvement initiative, and data preparation for various reports. Turning to our education programs in FY23, OHR saw a significant surge in community engagement with a 36% increase in educational and outreach activities, reaching a total of 80 such activities across the district. Prioritizing in-person interaction, we hosted 2 engaging listening labs where we discussed disability and employment and source of income discrimination. Open houses in January and April served as proactive introductions or reintroductions sometimes to OHR and its resources for wider communities, all of which were further bolstered by our participation in diverse community festivals, heritage panels. These types of face-to-face interactions resonated with the community, fostering deeper connections and understanding, which we find is attributable to our increased number of new cases being filed at OHR. I also held quarterly meetings with our community partners to update them about various agency developments, as well as to address any concerns they may have when interacting with our office. Our public education focused on updates to the DC Human Rights Act, curating public awareness campaigns like our weekly social media series called the Protected Traits Tuesdays that explains protected traits in simple terms with a focus on newly added protected traits. OHR also improved training materials with clear explanations and examples and teamed up with community housing organizations to offer in-depth educational sessions on place of residence discrimination and source of income discrimination. These efforts didn't stop there. OHR continued training human rights experts, government employees, and others, getting high satisfaction ratings from participants. Thanks to these efforts, many more people now understand their rights and responsibilities under the updated law. As in years past, in December, OHR's communication team worked diligently to successfully coordinate the Human Rights Awards ceremony with our Commission on Human Rights. Thanks to the commission chair and OHR staff, the event garnered over 100 attendees and honored the district's human rights champions advancing disability rights, including a youth awardee who played an active role in local civic activities. OHR's Creating Safer Spaces program also celebrated significant achievements in FY23. The Care for Seniors training program, focusing on new rights and legal protections for LGBTQ+ and HIV+ seniors, successfully trained 25 trainers through 4 Train the Trainer sessions. These trainers then reached approximately 70 long-term care facilities, impacting 432 staff members by the end of FY23. Similarly, the Sexual Harassment Prevention Program certified 153 trainers in the tip wage industry, reaching 394 businesses and training over 12,788 individuals. Collaborative efforts with business partners, a working group, online and community presence, media posts, and reminders fueled the program's success. Notably, over 514 businesses submitted sexual harassment policies, with 333 being approved, ensuring proper reporting mechanisms. The Language Access Program also made significant strides in FY23-24 as well, enhancing accessibility for LEP and NEP residents. Thanks to the persistent efforts of our Language Access Director, 13 covered entities implemented multilingual phone trees, bridging language gaps, and ensuring critical information is accessible by phone. Additionally, field testing and signage audits ensured compliance with multilingual signage across DC government agencies, creating a more inclusive environment. Significantly, our LA team also invested in providing technical and quality assurance support for machine translations, and a language access database dashboard was launched to offer a visually intuitive overview of compliance metrics, empowering agencies to implement targeted strategies. This year, to celebrate the 20th anniversary of the Language Access Act, a panel discussion will be held in April, reflecting on the progress and discussing future strategies for linguistic inclusivity. The milestone celebration underscores the program's effectiveness in serving LEP and NEP individuals and its positive impact on DC communities. OHR's youth bullying prevention also saw significant process in FY23. Thanks to our program manager, school engagement soared, with data collection response rates rising from 76% to 88%, and annual staff training reaching 64% of schools, up from 52%. This commitment translated into increased training and outreach, with 14 sessions for schools and grantees, 5 parent sessions, and 9 youth events delivered. Technical assistance efforts also ramped up, with informational meetings held and 45 non-compliant schools contacted individually. Additionally, 72 bullying prevention policies were approved for DC youth serving grantees. These achievements demonstrate the program's dedication to fostering a safer learning environment for our youths in DC. I will now transition to discussing OHR's enforcement work. OHR's enforcement unit, along with our Alternative Dispute Resolution Unit, is now overseen by the newly created Associate Director for Enforcement. These teams are supported by attorney advisors from OHR's Office of the General Counsel, and the hearings, as you know, are held by our ALJs. In FY23, OHR received 132 more cases in FY23, totaling 1,222 initial complaints. We believe this surge in case intake signals increased engagement and trust in the system, showcasing positive outreach, accessibility, and stronger stakeholder relationships. We processed approximately 900 cases at intake. docketed 295 charges of discrimination, and issued dispositive decisions in 376 cases. Our 24% growth in case disposition compared to case receipt growth of 16% over the last 2 years shows significant progress towards our efforts to increase efficiency. In FY23, OHR sought to complete investigation in 50% of our aged inventory, and I'm proud to report that by the end of the year, we were able to meet this goal. OHR's mandatory mediation conducted 283 mediations and resolved 120 cases, resulting in approximately $611,840 in settlements and payments to complainants. Through the hearing process, our ALJs also closed a total of 13 cases and resolved cases that resulted in a total of $673,950 in recovery for complainants, making the agency combined total recovery nearly $1.3 million. Further, thanks to the commitment and dedication of our chief ALJ, we were able to publish a discovery handbook designed particularly with our pro se litigants in mind. Significantly, OHR attorneys spent extensive time before the DC Commission on Human Rights pursuing the public interest. While OHR does not represent complainants, we are authorized in the pursuit of a public interest to seek make-whole remedies for complainants or victims of discrimination. In FY23, OGC attorneys entered their peers in 20 cases and participated in 3 merits hearings, including one where complete relief was awarded for the public interest and respondent was ordered to pay over $50,000 in relief. Our agency attorneys worked to secure 13 compliance agreements from respondents, the most ever in OHR's history, which resulted in respondents being subjected to multi-year monitoring, requiring them to provide trainings and post policies that reflect DC laws. In a major victory, OHR was able to get a major national retail store to change its employment discrimination employment application nationwide to remove questions regarding criminal background. The 13 cases where VCA was entered also resulted in private settlements amounting to $436,550 for complainants. OHR's work in this area continues to be active, as just in January 2024 alone, we are on track to obtain 3 more voluntary compliance agreements that have also resulted in additional $210,000 in relief for complainants. Additionally, despite being short-staffed due to a personnel transition and extended absences, over the course of FY23, OHR's legal team reviewed 120 letters of determination for legal sufficiency and drafted more than 200 core work documents. As a result, in addition to the letters of determinations we issued, the agency issued 22 decisions on motions for reconsideration, 31 administrative dismissals, 48 decisions on motions to dismiss, and 78 decisions on motions to reopen. Further, OHR worked diligently on improving internal agency processes and procedures in FY23 and implemented several office memoranda, including the process for contacting represented parties, establishing procedures for unresponsive complainants, and procedures for handling bankruptcy of respondents. Additionally, in FY23, OHR worked to bring more clarity to the public about the investigation process. One of these measures includes the development of a notification form that is provided to potential complainants in employment cases regarding the election of remedy rule in DC Code 2-1403.16a. The notification form is prominently posted on OHR's website next to the employment intake questionnaire and is also individually provided to complainants on 3 separate occasions, with the initial scheduling notice, with the draft charge of complainant signature, and with the investigator introduction. The notification form also has been translated into Spanish. In looking ahead for FY24, OHR's priorities are similar to those in FY23, and they are as follows. 1, continued effort in case processing improvements and related public information. 2, continued effort in case management system and IT system investment. 3, continued investment in people, including recruiting, hiring, and retention. 4, improved informational sharing. And 5, of course, a new home for OHR. With regard to case processing, OHR continues to refine and add to its effort on improving timelines. These include dedicating specific teams with specific goals to close cases in our 3 categories of cases of older cases, existing cases, and new cases. While OHR was not able to get our fact-finding conferences off the ground in FY23, we were able to consult with agencies in New York, Massachusetts, and Maryland. And with the newly onboarded associate director, we are poised to begin implementation of this procedure in FY24. Additionally, OHR is working on implementing early resolution mechanisms for certain cases and will be piloting this initiative in housing. With respect to our goal of launching a fully working case management system, I am again proud to report with the onboarding of contractor IT specialists and data analysts, we are well on our way. These individuals have hit the ground running, and we expect to have a fully operational case management system by Q4 of this year, as well as improved data sharing on our website. Following on the heels of our success in improving employee retention and recruiting efforts, OHR will continue to support our people with external as well as internal trainings, professional developments, and team building opportunities. Finally, as OHR's work continues to evolve and expand, our agency is focused on not only educating the public on what we do, but also how the agency is doing in its many areas of responsibility. These efforts will be supported by our new IT specialists and data analysts. And to house our growing agency, we continue to work closely with the Department of General Services to locate additional space. In closing, I'd like to thank my team at OHR. OHR is only successful because of the hard work of its dedicated team and the commitment and leadership of our managers. I'd also like to thank the mayor, the deputy mayor, you, Chairperson Nadeau, and the council for always being champions for human rights in the district. I appreciate the opportunity to share this fairly long testimony, but I appreciate your patience and look forward to our plans for continuous improvement. This concludes my testimony, and I'm available to answer any questions you may have.
Thank you so much. Truly appreciate your testimony. So I'm going to go ahead and ask my questions in the order of the topic section sent in pre-hearing questions to hopefully make it easier for you to access the info. Are there any anticipated expenses or contingencies planned regarding the case management system?
Are there, I'm sorry,
any anticipated expenses or contingencies planned regarding the case management system?
Yes, let me explain the answer. So we have a budget for the case management system. Some of the funds, as you may have seen in our responses, have been obligated. It is currently going through the procurement process.
Okay.
I hope that answered it.
Mm-hmm. How does the actual progress of the OHR case management system project align with initial timelines and milestones?
Pardon me, when you say initial timelines, do you mean last year or?
Yeah, I mean, or what was the goal of getting this up online and where are we?
Right. So a few years back, we did seek to transition to a new case management system, and that current system is called DCRT. And that system we found was not working as efficiently and effectively as we needed it to. So we had to pivot. And so that's why we're in this procurement process now. And one of the lessons we learned also over the years is that we could not have really led this project without the experts of an IT specialist.
Got it. And now you have that person.
Yes, ma'am.
Okay. Are there any notable deviations or delays that you're expecting as you go forward?
I don't think so. Our IT specialist is pretty motivated. He's gotten very good understanding of our processes. But there can always be, of course, unanticipated delays due to the procurement process. So I can't speak to that. But on our side, we have gotten our ducks in a row, so to speak, and we are just waiting for that process to take its natural course.
Great. And you mentioned the project's on track, slated for completion by the end of Q3. All right, I think we're good on that. Let's try not to beat a dead horse here. It's been a long day. Okay, so should the committee expect to see any budget enhancement requests in the mayor's budget next month on items related to operations or capital improvement projects?
I would have to get back to you, council member. Frankly, I just don't recall because I've had a a viral infection for the last 2 weeks, and so my head is spinning a little bit today, so I apologize, but we will get back to you.
All right, so regarding the Language Access Act of 2014 and the reallocation of funds, could you elaborate on where the funds were reallocated from?
I'm sorry, can you repeat that?
Yes, where were the funds for reallocated from for the Language Access Act of 2014?
Where were the funds reallocated? Perhaps, Adrina, could you address that? If not, Councilmember, we will certainly
Come
get back
back
to
to
you.
it. Okay. So we heard from public witness. Oh,
I'm
Adrina.
sorry, I'm here. I couldn't hear the question.
Oh, yeah. So there, my understanding is that there were some Language Access Act funds reallocated. And can you say where the money came from?
Reallocated where? I'm not understanding.
All right, we'll get back to you with the specific budget lines so that we all know what we're talking about. Okay. And then we heard from public witnesses about their struggles with language access, even with the Language Access Act in place. Director, you mentioned in your testimony that a panel discussion on the act will be held in April and will include a discussion of future strategies for language inclusivity. Can you talk about the strategies you're considering?
I think we're open to discussing different strategies that the community has to offer, and we want to have an engaging discussions around that particular topic. But if my language access director wants to say a few words, I'll defer to her.
Sure, thank you very much for the
I'm
opportunity.
so sorry. Hold on, pause. I should have had you introduce everybody who is with you.
I'm
Let's
sorry.
do that.
Sure.
Then we can continue.
Sure.
Okay.
And my apologies as well, as I mentioned,
Okay.
my head is not screwed on
It's all
perfectly
fine.
today. To my left here, I have Ayana Lee, our Chief Administrative Officer, and she's one of the individuals who was promoted internally. We have here our Language Access Director, Rosa Carrillo. She's been with the agency quite a long time and a huge asset. And then we have our General Counsel, Andrea Goplerud.
Very good. Okay. Familiar faces all, but wanted to make sure we had that on the record.
Sure, no, thank you for the opportunity. Again, my name is Rosa Carrillo, Director of the Language Access Program at the DC Office of Human Rights. And happy to celebrate the 20th anniversary. What a better opportunity to talk to the panel of language access stakeholders, including government agencies, and as well as coalition members and community members. That's one of the strategies that Director Kine just mentioned. It would be to talk about the past, the present, and the future. What specifically we're looking into this conversation is to ensure that what is in place right now, the language access resources and tools that are in place are working, are not working. How can we better improve? Now, in terms of policies and best practice, how can we combine both? And if the act has any specific provisions that we can enforce and better interpret the law so we can really translate that into best practice. As a matter of fact, we will be able to discuss what we just included is multilingual font 3 for cover entities with major public contact that we can discuss better in the panel discussion, how that better helps individuals who are accessing services through phones rather than the website. So some individuals has preference on doing that and probably phone or website. So those are kind of the strategies that we're going to talk with the community and the panelists.
Wonderful. Thank you so much. Now, we also heard about, we had testimony about where the non-compliance with Language Access Act actually ends up, right? What are the limitations OHR has? So what are your thoughts on OHR being granted additional authorities, such as the ability to fine non-compliant entities?
As you know, I think we've been down that road before. And so we're happy to take a look at any proposed legislation you may have and work with your office to provide our perspective on the operation of that kind of proposal.
Okay. For laws such as the Prohibition of Marijuana Testing Act of 2021 and the Medical Necessity Restroom Access Act of 2021, which lack dedicated funding for enforcement, are there particular aspects of enforcement such as investigation procedures or outreach efforts that are hindered by resource constraints?
Yes.
How much funding do you think is needed to rectify that?
I'd have to get back to you. We'll take a look at the FIS that we provided previously and then, reassess today. You would like the assessment for both bills, council member, or both laws, pardon me?
Yeah. Yeah, that would be good. Just, it's a resource question, wanting to make sure you're all fully staffed. Considering the Second Chance Amendment Act of 2022 and its enforcement challenges due to insufficient funding, could you elaborate on how the lack of resources specifically impacts the agency's capacity to adjudicate complaints and enforce penalties against criminal history providers?
Sure, I think the same concern as the other two laws, that without a dedicated funding, we wouldn't have sufficient resources with respect to intake, investigation, outreach, education, any policies, guidances, documents that have to be created and translated. And again, we can get back to you with the needed cost if you'd like.
That would be great. I am glad to see the Domestic Worker Employment Rights Amendment is fully implemented. I do have some questions. The agency published an external guidance document regarding the amendment. What is that exactly?
We issued a guidance document. We have a number of enforcement guidance documents on the books, and one of them is on domestic workers inclusion. And so that explains what the law does. And so folks understand how this works, particularly, for example, that's not an additional protected trait, but that every protected trait applicable in employment will now apply to domestic workers. So that kind of nuanced differences are things that we provide in the external guidance document. We also, of course, issued our press release. We're very proud to have gotten all of these things well in time for the effective date. My team here, the general counsel, as well as my associate director sitting behind me, James Yu, they all worked hard along with my communications team to make that happen. Is there anything else to add, general counsel? No? Okay.
Could we receive a copy of the guidance document?
Absolutely.
Great.
It is also listed on our website as well prominently, and so we're happy to point you to where it is.
Fantastic, even better. We'll take the link.
And it's translated.
I would expect no less.
Yeah.
Hello. Okay. Thank you, though, for mentioning that. It's important to always affirm that that's what we are doing. So what do you think the impact has been so far on, for employers, workers, and other stakeholders since rolling that out?
It's hard to say because it's early in the life of the law, so to speak, but we continue to work with our community-based organizations. I will say, as others have said throughout the hearing today, that there is a challenge with communicating with our employers because now we're talking about homeowners, individuals that are not particularly organized in a group or in a way where we can reach them in masses. So we are, as we always have been, very open to ideas from you, the committee, or the public about how we can better educate our individual homeowners. But one of the strategies that we continue to employ in FY24, for instance, is to get to the ANC meetings and to spread the word in that way. We've done social media campaigns. We've done various training sessions. But I think while we have reached a vast number of potential victims or domestic workers, we still have work to do to reach the potential employers.
I have one cringy suggestion, which is posting on Nextdoor. Yes, you understand why it's cringy, but I see your comms guy back there looking up. All right. I'm just thinking, in the olden days before COVID, it would be civic associations, but so many of them don't exist anymore, even their neighborhood listservs. You can make some headway on neighborhood listservs, but I feel like if you want to reach the people that we don't all always talk to all the time, that's one way. And you can post things without allowing comments.
Thank you.
Learned.
Well, we will think on this.
Maybe preferable. Anyway, just an idea. And could you say a little more about the content and format of the internal trainings that OHR conducts for staff and the commission regarding the domestic workers law?
Sure. Like any other new laws that we would begin to enforce, actually, it starts very early. As soon as the law has been legislated, introduced, we discuss it extensively at our staff meetings, for instance. And once it does become law, our general counsel and the OGC team does a lot of thoughtful measures to create training materials, internal tailored training materials for our team.
Great. And can you elaborate on the key topics covered in the virtual workshop hosted in partnership with DOES's Office of Wage Hour Compliance and the National Domestic Workers Alliance?
The one that we recently held in winter of 2023. Yeah, so we mostly dedicated our time on talking about domestic workers, but I will get back to you with fuller details from my team.
Okay. And what plans do you have to continue supporting the community in understanding and exercising their rights under this law?
Under domestic workers?
Exactly.
Perfect. Yes, as I mentioned earlier, we will continue to, of course, engage with community-based organizations. We are holding listening labs. We continue to talk about it in our HRLs, which as a matter of fact is happening this afternoon as we speak. Again, we will attempt to share more information with ANC meetings, which, admittedly has been a difficult feat with arranging meetings with ANCs, but we are diversifying our efforts. And then, we also hold library hours in neighborhoods. So we continue to include discussion of the new coverage at that venue as well.
Right. And how do you plan to monitor compliance with it moving forward?
Because we do have now an IT specialist and a data analyst, we have begun to track the number of complaints. And so once we start to have these complaints trickled in, we can start to talk about where the compliance levels are and probably tailor our educational efforts, based on what we learn from the complaints that we get.
Okay. Great. Let's discuss the Eviction Record Sealing Authority Amendment Act. How have the free external guidance documents published by OHR regarding source of income discrimination and the protected trait of sealed eviction records impacted understanding and compliance among landlords, tenants, and other relevant stakeholders?
I don't know that I can say specifically about that particular impact right now. Again, it's also early, but what I do know from having heard from community stakeholders, including attorneys that file at our office and judges that look at these documents, is that these guidance documents are extremely instructive and helpful for, again, not only the potential victims, but employers, housing providers, anybody, any stakeholder, right? Attorneys, and even judges as we speak, who point to these documents to have a better understanding of how we, the OHR, as an enforcement agency, interpret these laws. And it really is an opportunity for also community-based organizations and advocates to let us know if there's information that we should clarify or add or subtract. And so we're looking to do that at every chance we get when we have our quarterly meetings with the community-based organizations.
Thank you. How have the training sessions that you've conducted for intake and investigators equipped staff to effectively process complaints related to allegations of violations of prospective tenant screenings under this law?
Well, I think, as we know, better training means better understanding and better anticipation of issues, because sometimes, as you know, complaints don't come out with, I want to allege a complaint under the Eviction Record Sealing Amendment Act. And so, our team is better able to spot the issues in a given fact pattern once we have training. And so because we've done these trainings multiple times now, that our staff is equipped to make those identifications fairly quickly.
Well, that's a good point that we haven't really talked about, which is sometimes these complaints don't come in as, I believe I am under this protected trait or this law, et cetera. And so those doing the intake have to sort of read between the lines. Okay. Right. Okay. So have there been any notable challenges or successes in applying this knowledge to real world cases so far? Yes.
In terms of
the
eviction record?
Yes.
Yeah. So again, I think that I'm not sure I can say anything more than what I've said, but I can.
That's fine.
Okay.
We can leave it there.
Sure.
All right, let's go to unfunded legislation. Are there any initiatives or advocacy efforts being undertaken by OHR to secure funding for the implementation and enforcement of Second Chance Amendment Act, Marijuana Testing Act, Cannabis Employment Protections Act, or Medical Necessity Restroom Access Act?
I think our understanding is that hopefully council would take a look at that and fund it once we are able to provide you with the updated cost figures.
Okay. All right. So could you talk about the specific recruiting efforts and pipelines that you're working to establish at OHR in this fiscal year?
Sure. Similar to last year, we are continuing to attend various job fairs, which has proved very successful. We also expanded our reach by going to diversified career fairs. Another effort we implemented, thanks to our senior advisor sitting behind me also, is that we reached out to various law schools and paralegal programs, including ones that are dedicated towards removing barriers for returning citizens. And so we were successful in those efforts in establishing the pipeline from, getting law clerks, getting, interns, getting fellows, right, to come and work at our office to gain an understanding and to not lose sight of the investment in the trainings that we provide and exposure that we provide to those individuals. And then I'm going to turn over to my CAO, Ayana Lee, to see if she has anything else to add.
No, thank you. I think that you covered all points.
Thank you. Regarding case processing improvements, what specific performance plan goals have been set for each team within the agency?
Sure. I believe last year really was the perhaps first, if not the second year, where there were specific targets identified in performance plans. And so similarly this year, I have sat down with our 4 enforcement teams to specifically identify specific number of cases for each teams to close in those 3 categories of cases that we spoke about. And so having that kind of specific targets allows us to track and monitor and make sure that we're able to achieve those goals.
Great. And how will OHR expand its data and information sharing efforts related to case processing on its website by the end of FY24? Are there any plans to enhance accessibility or user experience for stakeholders accessing this information?
Always, as you mentioned, our process may seem linear, but it's very complicated. So we're always looking to refine how we might communicate that information. And I'm a believer in visual learning. And so we are trying to always refine our outreach materials to that end. But I'm really excited to report that with respect to our website, we want to provide more information to the public and our stakeholders on the process and the data that we have to share. So that's why our IT specialists and our data analysts are crucial positions for OHR to retain in order to actually launch that effort to provide, as I mentioned, not just what OHR is doing, but how OHR is doing with respect to all the numbers that all of us want to know at our fingertips.
Great. Regarding the ongoing updates to the case management system, what specific enhancements or improvements are you planning to make?
So a major improvement that we're expecting to make is for the database to actually manage cases, which means that we should be able to get into the system and, any investigator, any manager, the director, the associate director, right, all of us should be able to get into the system, have a dashboard that talks about how many cases are in which unit, how many days has it been pending, where are we on the intake, how many days has it been with mediation, why hasn't this case closed in, from 2019, things like that we're not able to get at our fingertips right now. And moreover, to have our data analysts then have access to the data to then look at analyzing the data every month so that we can be assessing how we're doing. It's an important tool in case management that we just haven't had, to be able to say, how are we doing with our goal? Where are we with our goal? It's great to have goals, but it's no good if you don't know where you are by a given time and period. And so that's really the biggest improvement, is rather than a case management system being a document storage, but to be actually able to manage, send reminders to our teams, our investigators about, hey, this position statement has been overdue by 5 days now. Let's go track this down and see where it is. And so to close those gaps in extensions and delays that we experience to help overall really better manage our time, essentially.
That's great.
And someday, and I hopefully my IT specialist won't kill me for saying this, in the near future, ability to file online, of course.
That'll be huge.
And I should revise that statement a bit. We can file online right now, but to file directly into a system.
Into the system.
Right.
Yeah.
Where then we can capture the data more.
So you then don't have to manually enter it into another
Exactly.
system.
And have
Yeah.
human error issues or human, absence gap issues.
Yes, that seems like it'll be a huge improvement. All right, can you provide updates on the progress of identifying a new location for your offices?
Yes, my CEO here and the rest of my team have been working diligently with DGS to identify a permanent home. We're looking for 2 homes, temporary home and permanent home. And right now we are making great progress in temporary home. And I think we actually have meetings coming up in the weeks to exactly know what the build out work will be for the need that we have to have space for all the teams that we have. So in other words, we're not going to move to a central location right now, but we are looking for additional space within a current building that we're occupying.
Got it.
Anything to add?
That's correct.
What about the permanent?
Permanent will be a little bit more challenging, but we are still looking because, OHR doesn't have a capital budget.
Mhm.
And so that also makes it a little bit more challenging for us to find space on our own.
And just to add, in terms of working with DGS, so right now the main focus is the temporary space. But at the same time, they are seeking a more permanent space that will hold the collective agency. But right now, the priority is just finding space right now for the overflow of staff.
Mhm. And the telework policy is not going to help you reduce office space.
Correct.
Yeah. It's something that's come up in a number of hearings.
It will expedite the processing, hopefully, of our new space.
Yes. What would?
And hopefully, it will expedite the time it takes to have a new space.
What would?
The telework policy.
Oh, well, even the telework policy is now 4 days in person, so that doesn't help you. Oh, I see.
No,
Because
the
it
fact
makes
that
it
we
more
have to comply,
urgent.
correct.
Yeah. Interesting. Okay, well, there's a bright side. It's great to see the agencies trying to nurture career growth for personnel and increase retention. And I know how difficult the competition is with the federal government. Are there any specific metrics in place to assess the impact of staff satisfaction and retention rates?
I don't think we have a specific mechanism right now that I can think of, but let me turn over to my CEO, see if she has any ideas.
Sure. So during the performance management process, we encourage regular check-ins with our managers and our employees. Something else that we want to start implementing are stay interviews. So speaking with our staff to see if there are any ways that we can talk about ways that we can improve their experience or what, they would like to see in order to stay with the agency.
So I've never heard that phrase before, but it sounds pretty self-explanatory, but let me make sure. So a stay interview. So that's essentially like, what would it take for you to stay?
Correct.
Okay.
Exactly.
The opposite of exit interviews.
Got it. That's very interesting. I've never heard that before. Maybe I'll start using it. Thank you. In your response to question 42, you stated that the tipped wage documents and certifications portal, which is the online platform designed to ensure compliance with the Tip Wage Worker Fairness Amendment Act of 2018, will not be granted access to the public, or the public will not be granted access to it. What's the legal reason for that, and how do employees or the public know whether a business is in compliance?
Right, I think that whenever there is, and I'll let my general counsel speak on that in a minute, but we are careful with guarding the information that we get. Of course, if the public wants to FOIA information, we're always in compliance with FOIA provisions. So specifically with the tip wage program and the sexual harassment information, there can be sensitive information that is included in those compliance documents. But General Counsel, do you want to add anything?
No, I think it's just that, what we ask for in compliance could reveal information about potential complainants, even if they are generalized, but if they, they could identify who the person actually was. So we want to be sensitive of that and kind of balance, privacy concerns and, along with, being transparent. So certainly we welcome FOIA requests where we can appropriately balance those, concerns rather than kind of just a wholesale, letting the public see kind of the raw data.
Nobody welcomes FOIA requests.
Well, it's a first for everything. The attorney who does that is on vacation this week and she's gonna kill me when she hears it.
Well, you heard it here first. But that makes sense. Thank you for clarifying that. All right, so let's move on to the agency's case backlog. What is the number of cases currently backlogged?
So let me just give you some data. So currently we have let me just make sure I'm looking at the right chart. I have several charts.
Take your time
here. Okay, here we go. As of January 2024, we have total 261 cases that are FY21 or older, 111 cases that are FY22, 134 that are FY23, and 105 that are FY24.
What's the oldest case currently open?
What do you mean, what year?
Mm-hmm.
I would have to get back to you on that.
Okay. At what point does OHR consider a case backlogged?
So we are redefining how we view age cases a little bit here. And so the way that we've looked at our case inventory now is that FY22 or older would be current in this current fiscal year. FY22 or older would be age cases. FY23 would have been existing cases. And FY24, of course, would be new cases.
Where do you have you identified any parts of the process where cases seem to get stuck?
In short, council member, this is an issue of no good deed goes unpunished.
Mm-hmm.
What I mean by that is that we may be a little too generous in extensions. We may have layers of reviews that require sort of trimming down. And so really those are the delays. But sometimes the process requires these different, even if there are delays, to take its course in order to give everybody the opportunity to submit their materials. And for us to be able to abide by the trifecta of cases from Court of Appeals that continue to dictate how and to what length we must have in terms of the evidence and information before we can actually make a conclusive decision. So those are the three things I would say is, trying to be generous with our time to the parties and being dictated by the amount of work that we have to put in based on the case rulings from the Court of Appeals.
And are there any ways to update that process that don't undermine the outcome?
We're trying,
Yeah.
we try to have policies where after a first extension request, a second extension request has to be approved by a supervisor, absent exigent circumstances, but that still takes some time. At the end of the day, we have to get the materials we need in order to make a sound, legally sound decision.
Yeah.
But I think that a couple of ways that we can try to expedite the process is to do the fact-finding conferences and to implement this early resolution mechanisms, which we have found have been successful for a number of comparable agencies in the country, including Massachusetts and New York City, which are, again, large jurisdictions with large caseloads that have similar challenges.
Mm-hmm.
So we're really hoping that our ability to test these mechanisms will expedite the time, right? And to ensure that we're not using the same process for every single case, because not every single case requires the same type of, same depth of investigation.
And do you have the authority you need to try these things out?
Yes.
And when you say that you may be too generous in extensions, the second one has to be approved by supervisor. So is that extensions for the OHR staff working on the case then?
No, that's for extension requests made by the parties, either the
Okay.
complainant or respondent.
That's what I thought, but then I got
Yes.
confused by supervisor. Okay, so in which case that is something that ostensibly helps either the complainant or the respondent provide a more complete answer?
Correct.
Okay, yeah, and I think that's something that we see in all of our adjudicating bodies. Okay. And how does OHR prioritize cases for investigation, particularly in light of the number of pending cases and limited resources?
So I will tell you specifically our goals. Let's see. So for instance, our goal in investigation is to complete 70% of our FY21 or older cases, 60% of our FY22, 60% of our FY23. FY24 cases, it's sort of first come, first serve system. So we will try to get to them so that they don't become age, but we have to go ahead and tackle the older cases, of course.
Got
We
it.
also
So
have
the
specific-
prioritization
yeah.
is age of case.
Yes.
Okay.
Yeah. And we also have specific goals for our ADR team as well as our legal team that reviews the work product for final legal sufficiency.
And so there isn't any sort of classification of type of complaint in terms of that's higher priority or lower priority?
Not yet.
Yeah. I mean, do you think that's something, is that a good idea? I'm not asking the question because I know the answer.
That's
There's
certainly how-
23 protected traits. Who's to say which one is most important, right?
Right. No, so if we did prioritize it, it wouldn't be based on the, what kind of protected trade. It would be complexity of the claims.
I see.
And so EEOC certainly does it in that manner where they do classify their cases based on complexity levels.
Okay. So that might be something you'd consider at some point.
Yes.
And what sort of things would you, I mean, I guess what has to happen before you even begin that consideration? What else are you working through?
I think we have to complete this cycle of foundational work that we're doing right now. For instance, keeping our enforcement teams going, retention, reaping the benefits of our investment in training our enforcement folks, as well as our now efforts to have our investigators, more experienced people conducting intakes rather than entry-level folks doing intake. And so getting all of those foundational work done, having a good case management system will allow us to go to that next level of triaging cases in a way where we can prioritize.
That makes sense.
Yeah.
I look forward to it. Okay.
Thank you.
The committee has received complaints from residents regarding the long periods of a lack of movement in their cases, and we heard testimony on this issue today. One complaint in particular reached out to the committee staff in May 2023 regarding a discrimination case she filed with the agency 2 years ago, with no update from the agency during that time. And the previous Committee on Government Operations and Facilities adopted a policy recommendation that the agency establish a policy that parties are entitled to receive case status updates, including estimated wait times for next steps, no less than monthly upon request. Has OHR been able to adopt such a policy?
OHR does contact the parties to let them know about next steps. It is hard to anticipate days, I will say, because of the contingencies involved and other things beyond our control. But we are very responsive. I think your team can attest to this, as well as other council members' offices. When we do get requests, we are responsive, and we do keep to the mayor's policy of 24 to 48 hours of responding. And I do have a dedicated staff, our senior advisor, who diligently reviews requests for this kind of information and is constantly either on the phone or email to respond to the parties. And now that we have an associate director for enforcement, he will also ensure that there are timely correspondences with the parties by the investigator or the manager.
Thank you so much. In response to question 51 in your pre-hearing responses, could you elaborate on the criteria or factors considered when determining the closure timeline for cases within 1, 2, or 3 years of docketing?
Sorry, I'm gonna flip to that question.
Yeah,
I
absolutely.
may also need you to repeat to it if you don't mind.
No,
Councilmember.
no problem.
Let me get to that.
Yeah, when you get there, I'll
Did you say
repeat it.
52?
51.
51. Okay, go ahead. I'm
Okay,
sorry.
so could you elaborate on the criteria or factors considered when determining the closure timeline for cases within 1, 2, or 3 years of docketing?
You mean, how did we come up with these data points?
Yeah.
So I think we simply would have looked at, when these cases were closed as the question asked, after being docketed.
Okay.
Yeah.
Sort of a look back.
Yes.
Okay. And do we have any benchmarks or performance goals set for case closure timelines?
So yes, our investigators are, again, working on the percentage of completion in investigations, as I mentioned, based on each of the year of the case. But also we strive to complete investigation within 180 days. Now, again, I will emphasize complete investigation within 180 days because the other processes like intake and mediation can take some time. That's, again, a lot of the times out of our control with rescheduling the interviews and the mediation sessions.
In FY22, the agency received $100,000 to support an independent assessment of case review timelines. I think that's called the industry standard study. When can the committee expect to receive this study?
That study had the underlying work has been completed. It's just a matter of finalizing the report. And so we're hoping to issue that in the next few months after all the reviews that it'll go through.
Where is it now? In the agency still?
It's with me.
Yeah, okay. And then it goes all the way up?
Yes.
Yep, okay. I want to discuss director's inquiries. From my understanding, this is another tool in the toolbox which allows you as the agency director to identify and investigate discriminatory practices and policies. And last year during performance oversight, you told me that these director inquiries are labor and resource intensive. Can you elaborate on that process and walk me through it? Because I just want to understand it better. And in particular for cases related to housing discrimination or source of income discrimination for voucher holders.
Sure. Yeah. As an agency, we realize that that is a great tool in our arsenal of tools that we have. And as director, it's something that I would like for us to pursue more. The challenge, of course, lies in, like I said, our attempts to do this foundational work of reducing our age inventory and making sure that we are investing and reaping our investment with respect to the training that we provide to investigators. So all that said, the challenge is that the way that you identify director inquiry cases is one of two ways. One, a community-based organization or service provider will come to us and say, hey, I have a number of these kinds of issues that are occurring, and I don't have a complainant, but there are some issues that I want you to be aware of. And so we can do a director's inquiry based on that. That's the easy route. The harder route is where our team, whether that's the investigator, the manager, the enforcement director, or OGC, our legal team, would have to spot a pattern, meaning that there have been recurring complaints against the same entity and where we have found probable cause, not just the allegations, but where we have found probable cause against that kind of entity, and then to seek a director's inquiry based on the practice or pattern that we're seeing. So that, again, requires us to come out from underneath the weight of the current workload that we have in order to spot those patterns, and that's the challenge.
So the first is somebody from the outside brings it to
Yes.
you, and the second is the staff work lifts it up to the top.
Yeah, correct, exactly.
Okay. Does OHR communicate or work with the Attorney General on any housing discrimination or source of income discrimination cases related to housing vouchers?
Yes, we refer lots of cases to OAG.
All right. And we heard
I'm sorry, General Counsel wanted to add something? We're okay.
We're good. Okay. We heard testimony today advocating for OHR to accept attorney-drafted charges without revision. Apparently, there was a pilot program allowing this in 2019. What happened to the pilot program?
The pilot program, I think, came to its natural termination, and then there was leadership transition, and then COVID. So I think it sort of fell off in that way. But I am happy to tell you that this is a discussion we've had internally, and we are looking to bring that back. But like anything else that we do, we have to have guidance and policies and parameters around it. And so that's what we're working on now. And so I know that my team is working to launch something in the coming months to the public about our ability to accept attorney drafted charges.
Great. Just circling back to recruitment, how does the agency plan to ensure diversity and inclusivity in its recruitment efforts?
I think that as we successfully did in FY23, we will continue to diversify our approach by going to various career fairs throughout the different wards in the city. We will continue to work with all of the law schools and paralegal schools in the area, not just a select few. And then we will continue to work with offices like the Mayor's Office on Returning Citizens Affairs to tap into the arrangements and programs that they have for removing barriers for returning citizens.
Great. Thank you so much for your testimony, everybody. Thank you for powering through your illness to do it. Never would have known if you hadn't mentioned it. So thank you. I appreciate it. And that will conclude today's public oversight hearing. So
Thank you,
for those,
Chairperson.
thank you. So for those who plan to submit written testimony for the record, please do so by going to the council hearing management system at lims.dc.gov/hearings. The record will close on March 6th at 5:30 p.m. The time is 1:42 p.m. and this hearing is adjourned.